people who aren't as experienced. And we have a clock here. It will count down the 15 minutes you have. When you have 90 seconds left, the light will turn yellow. When time runs out, the light will turn red and we'll start counting up. If the light's red, that's not how much time you have left, that's actually how much time you're over. If the light turns red, you can finish your sentence, but please don't say anything else unless you're answering a question from one of the judges, in which case, please do finish your answer. There's no rebuttal in the Massachusetts court. I assure you we have read the briefs, we have looked through the record, and so we are familiar with the background of the case, and you'd be advised to go right into your argument and not give us the background. With all that being said, I'll call the first case, number 24P 983, Commonwealth versus Erler. Whenever you're ready.
Good morning, may it please the court. My name is Neil Tassel. I represent the appellant, Albert Erler, who's present in the courtroom today. I'll accept your advice and move past the facts. The first issue I want to address is whether or not it was ineffective assistance of counsel to not advise Mr. Erler of the potential loss of his Second Amendment rights by taking this matter to trial, risking a guilty finding or conviction, rather than request a continuation without a finding, which was and has always been the standard disposition for a first offense, OUI, and which counsel in their affidavit provided evidence to the trial court that the matter apparently had been conferenced and the Commonwealth would have agreed to a continuance without a finding. A continuance without a finding would have avoided the dire consequences that Mr. Erler faces, the permanent loss of his Second Amendment rights, specifically enumerated constitutional right. I draw the parallel, as others have raised, of the Padilla scenario in which it is ineffective assistance of counsel to advise or misadvise a client about the loss of immigration rights. Now, I recognize that there is some precedent that has been argued to control this issue. I suggest that it does not. The two cases that are most commonly cited, Indelicato and Lankowski, are in opposite in my view. They were relied upon recently by a panel in this court to deny a similar argument, one that I think was not presented accurately or correctly to the court. Since 1968, any individual who has a conviction for a state misdemeanor that carries more than 2 years potential incarceration is permanently disbarred from the possession of firearms. Now, Indelicato and Lankowski were both decided prior to the current state of the law regarding Second Amendment rights. At the time that they were decided, these were matters which were somewhat discretionary, whether or not an individual could be issued a license to carry firearms in the Commonwealth. At that time, there was no individual right to possess firearms in the Commonwealth that had been decided and been law since 1976 in Brown. A license to carry, and whether or not the suitability determination to issue a license to carry.
License to carry, but you could have gotten a FID card allowing you to have a gun in your home as of right back then, right?
True, although the FID card is a far cry from the rights that are enumerated and protected by Bruin and later cases, which includes the right to possess firearms for self-defense outside of the home. There was still an element of discretion in an FID card, even though the statute is written in a manner that suggests that it should issue. There's always been a suitability determination that was available to chiefs if they thought a person was not of correct character.
I thought suitability got added in like 2014 with the firearm reforms of that time for FID cards.
It was, but now that we're talking about self-defense outside of the home, possession of firearms outside of the home, the two rights are in opposite. It's a far cry to be able to possess a long gun in the home versus carrying a handgun outside of the home for personal protection. And so I grant you that it was a FID card could have been obtained without the same element of discretion, but either way, the conviction would still bar the possession of firearms and make the right, not the license not available, whether it was an FID or LTC.
Could a chief have found your client unsuitable based on the quaff? I know it's not an automatic disqualifier.
I have never seen a first offense OUI continuation without a finding cause a chief to deny on suitability grounds. That being said, we're not talking about simply a license that might not be issued in Massachusetts. We're talking about the permanent loss of a constitutional right extending throughout the United States. So it might be common for somebody, if they wish to exercise the constitutional right, to leave Massachusetts if they're denied on suitability grounds. But this disqualification will follow them for the rest of their lives wherever they go in the United States.
Is there evidence that was a concern for your client that he might move at some point?
Not in the affidavits. It happens to be true, but not in the affidavits. The fact of the matter is that because of the way this case turned out, the movement doesn't assist him with the problem of his permanent lifetime disqualification. It's irrelevant to him now from that point of view if this conviction remains. As I indicate, the most recent decision by the court last year in a different panel doesn't really address this issue at all. It still talks about the denial of a license to carry and doesn't go to the heart of the issue, which is the permanent lifetime disqualification. Now, I grant that there are not many cases that identify the equivalence of the Padilla issue with the license to carry issue presented here and the Second Amendment issue presented here, because the determination about whether or not a person goes to trial is less of an issue in the immigration scenario than it is in the Second Amendment scenario. The reason being this: in the immigration scenario, a continuation without a finding is the equivalent of a conviction. That doesn't apply to the Second Amendment disqualification. Since 1968, as I say, any misdemeanor of a state in a state with a guilty finding creates the disqualification. A continuation without a finding does not. So this would be the first decision that addresses that exact issue, whether it's ineffective to misadvise or not advise a client concerning the implication of a conviction on the Second Amendment rights. Now here, counsel and the appellant both identify in their affidavits to the trial court that this was a special concern of his. They had been acquaintances for about almost 2 decades. Counsel knew that that the appellant had firearms, was both a hobbyist, and relied upon them for protection in his business, and yet did not raise the issue at all. Instead, what I suggest, went forward with undue confidence of an acquittal, and obviously we're at the point we are now.
I'm sorry, what's the authority for a quaff not having the same consequence?
So the 18 U.S.C. 922 discusses convictions, and because of that, a continuation without a finding, which obviously avoids the conviction, does not create the disqualification. That same limitation does not apply in the immigration scenario, where it's an admission plus the possibility of a sentence that creates the immigration concern. Now, once the decision was made to proceed to trial, there were a number of ineffective assistance issues that arose. As I've indicated, there was a almost non-existent request for discovery by counsel prior to the trial. He failed to seek the booking video. He may or may not have had the body-worn camera. There's some discrepancy. His affidavit says that he did not have it, whereas, as the Commonwealth points out, he filed in limine to exclude it and pointed to some specifics, causing one to think that he probably did have it, but didn't recall it when he provided affidavit to the appellant. Nevertheless, the booking video was an important piece of evidence that wasn't reviewed. There was a color photograph that he said he was going to obtain but never did, which could have addressed some of the.
How can we determine how helpful that would have been without seeing it?
Well, fair, one has to make certain assumptions, but when you see the evidence in the trial, which is that at the time that the appellant was stopped, he appeared to have no difficulty operating the car, he had no difficulty speaking, he had no difficulty obtaining his license and his registration from the car. So the reasonable inference is that that same composure and evident lack of intoxication would have continued for the duration of the booking video, in which there are many points of discussion, there's many points of manipulation of a pen, perhaps of a phone, which is frequently seen. But the point is fair that it calls for some speculation,
Well,
but I think it's a reasonable.
If the evidence the jury heard establishes the booking video would have shown nothing of intoxication, where's the harm?
I'm sorry, I don't.
You're telling me that we can determine the booking video would have shown him not looking particularly intoxicated because of the evidence that the jury did hear about how he could drive fine and produce the thing. So what's the prejudice?
So the notion that it might be cumulative is fair. However, the evidence of intoxication was so minimal in this case. Obviously, it was sufficient to be concerned about it, but really the only evidence was that the appellant had slurred speech, and there's some discussion in the brief about that, had red eyes, and red and glassy eyes, but that his operation apparently was perfectly acceptable. He pulled over, he stopped, he was able to perform the motor skills that I just mentioned. So it's a fair point, but I do think that the evidence was so minimal that not only, to your point, that it would have been slightly cumulative, but it would have shown even more evidence of lack of intoxication, which was the sole issue. Instead of providing to the court the evidence that existed, counsel, apparently due to lack of preparation or not obtaining the evidence at all, was forced to go off on kind of an irrelevant tangent in argument of, well, trying to elicit from the police officer about whether or not the defendant wore contact lenses, whether there were allergies that he argued to the jury, of which there was no evidence at all. I think, again, it reflects the ineffective assistance that he got in the manner in which evidence was presented at trial, forced, I suggest, because it wasn't obtained, the actual evidence that existed, both of the medical condition, of allergies, if that was even of the case, or that contact lenses could have been shown to have made his eyes red, wasn't in his possession. Again, another issue was that he was promising evidence that almost immediately turned out to not be the case during jury selection. He repeatedly, during voir dire, suggested to potential panel members, I think 4 of which were seated on the jury, that the evidence was going to show a couple of drinks, perhaps 2 drinks, 2 to 3 drinks was how he asked it.
So, Counselor, I think I've figured out which jurors wound up deliberating. Do you have that information that I can check if I got the right numbers with you, or do you not have that?
It's the actual jurors that were seated are reviewed in the Commonwealth's brief. I cross-checked that, and I agree with those jurors actually being seated. So okay. It's the four of the 7 that actually heard the case, but I agree with that. To them, almost immediately after making, because the jury selection occurred very quickly, you can tell from the record, that almost immediately after they were seated in opening statements, the attorney, now apparently maybe perhaps having reviewed the police report prior to the opening statements, then said correctly that the appellant defendant drank 4 or 5 drinks at the Golden Banana, which I'll get to in a moment. Therefore, I suggest destroying any credibility that he had that he was going to be delivering the evidence that he had essentially promised them during the jury selection. Now, you don't see cases on this point precisely, but you do see cases in which opening statements counsel make promises to the jury that are not delivered upon. Everything in this matter is very condensed in terms of time and given the short nature of the trial. And so the temporal proximity, if you will, to his misstatements of the evidence, I think was completely, was further kind of enhanced. The other point that I want to raise is this issue of the irrelevant evidence being admitted into evidence of the golden banana. Now, the statement of the defendant was to the trooper that he had been at an establishment known as the Golden Banana. Counsel appropriately moved to exclude that evidence. That was denied by the court, who himself, the judge, said that he thinks that these clubs are immoral. Now, the Commonwealth points out that the judge tried to limit the impact of that by asking jurors if they thought it was immoral, but that doesn't really address the irrelevance of the evidence in the first place. And it creates the possibility, if not the probability, that if there were jurors on there who thought it was distasteful or somehow misogynist to attend such clubs, that would not have necessarily screened them out simply because they were asked in jury selection if they thought that the club was immoral. It had no point in the evidence. It had no relevance at all.
We're out of time, so I think we'll have to leave it there. Thank you, Counselor. Hear from the Commonwealth now.
Thank you, Your Honors, and may it please the Court, ADA Zach Gruby for the Commonwealth. I'll start the same space that defense counsel started, which is this claim that it's an ineffective assistance of counsel to not warn a defendant that a conviction could impact their Second Amendment right. This court has been pretty clear since 1996 when it decided in Delicado that this is wholly collateral to this issue. When further looking at Commonwealth v. Rodriguez in 2001, the court defined collateral consequences as something that flows or may flow secondarily from conviction or incarceration. That case looked at whether or not during a plea a judge had correctly, or the defense attorney had correctly advised the defendant as to the possible maximum penalty if he were to violate his probation. In that instance, the sentence was found to be a direct consequence because it flows naturally from the criminal conduct. In this case, I would urge you to follow in Delicado and then the cases, both Prescott and Lankowski, that panels of this court have decided in finding that this Second Amendment is wholly collateral to this issue. I don't believe that the recent case law similar to the panel in Prescott has changed that standing. If we were to look at Justice Alito's concurrence in Padilla, he states that there's multiple things in which a criminal conviction could bar us from, some of which have constitutional dimensions. And within that concurrence, he specifically points to the ineligibility to possess firearms. And while Bruin came...
I mean, it's a great concurrence, but it's pretty much not what the majority says.
Correct. However, if we are looking at Padilla, which was decided in 2010, that came out after Heller in 2008, which stated that there was a right to possess a firearm in the home for self-defense. And so this is already an issue that could have been contemplated by the Supreme Court when they were determining Padilla, because this was already on the radar. However, they stated that Padilla was unique in the aspect of deportation, and the Supreme Judicial Court of Massachusetts has also held in numerous cases that they don't view Padilla to be an abrogation of the direct and collateral consequences, but instead they view it to be unique to deportation as well. So I would ask this court to follow the precedent of Indelicado and the line of thinking from the Supreme Judicial Court that Padilla is limited to this context. If we're to move on to unless there's any other questions, I would move on to the other.
Yeah, how does one draw the line? Like, for instance, in the Bill of rights, many of the rights embedded in Fifth or Sixth Amendment are advised to a defendant who is changing a plea, are rights that a defendant must waive and give up, correct?
Correct.
But the Second Amendment has never been part of that, obviously. But let's say hypothetical, let's say you'd lose your First Amendment rights if you were convicted of a crime. Do you think we should be advising defendants of that? Attorneys should be? Look, if you're found guilty on this, you're going to lose your First Amendment rights.
Would
that be a direct consequence, or would that be something of import that a defendant should know, that a reasonable, competent attorney should advise a defendant before they made a decision?
I think that it would depend on the context or the way in which the First Amendment would be lost. We do place restrictions on the First Amendment, whether or not based on the location in which it's being spoken or things to that effect. I also think when looking at the things in which defense attorneys don't have to advise defendants of, there are things with the constitutional dimension there. I would argue that the right to vote, the right to not be confined in a civil confinement sense, all of those kind of impose upon constitutional dimensional rights.
But the founders didn't highlight those rights in the Bill of Rights, did they? Mr. Madison didn't include those rights.
Correct.
There's a hierarchy of rights. Would you agree with that, at least constitutionally?
Yes.
And number two is the right to bear arms, which is a right that all citizens have. You'd agree to that?
Correct. But as Bruin and Rahimi have articulated, this is not an unlimited right. We are allowed to place restrictions upon it, and they did state that the felon in possession rule, of which this statutory interpretation comes from, is something that they view as still being valid. So I would say that these restrictions or these regulations are in fair place. Turning to the other claims of ineffective assistance of counsel, defense counsel stated in his argument a few different things that I would just like to highlight. He stated that the defense attorney at trial didn't have the body-worn camera. However, the judge below made specific findings that the body-worn camera was had, that the parties agreed that that was turned over, and the Commonwealth stated at the motion for new trial hearing that the body-worn camera contained the booking video, which is the essence of what successor counsel now, my brother, is arguing in speculation may have contained exculpatory information that could have been provided at trial, but we aren't allowed to overturn a conviction based off of mere speculation. When looking also at some of the other claims, such as the colored booking photo, Justice Dickoff, you asked why it wouldn't have been attached to the appeal, and I had the same question, because when looking at defense counsel's affidavit, he states that he did have a colored booking photo. He states something along the lines of, or I should have used the smaller one that I had been provided. If that was clear enough for him to make a determination as to whether or not the eyes were bloodshot or glassy, then surely that would have been quite supportive of his claim to the motion for new trial judge and for this panel to review independently. Without that being attached, the motion for new trial judge was under no obligation to take him at his word. And I do think that where it wasn't in dispute that the body-worn camera had been turned over, her specific highlighting of that within her decision was in a way to state that the booking video had also been turned over. She didn't make any specific findings to that, but that was stated by the Commonwealth in argument at motion for new trial without any objection from defendant, without
Why are those statements evidence? I mean, one thing if you had an affidavit or had provided it yourself. I mean, I know you weren't the one who litigated this in the district court, but can we take that statement of counsel as evidence?
I'm not sure that you can take it as evidence, but I think you can take it to undercut the defense counsel's affidavit. He chooses his words fairly carefully in his affidavit, I would say. He says he neither sought nor reviewed the booking video. He never claims that he didn't receive it. And so I would say, although that might be viewed as some to be splicing hairs, there's no claim by him whatsoever that this wasn't within his possession. And he specifically filed a motion in limine to exclude the body-worn camera, citing McGrail issues due to the field sobriety tests. So I would say that there's no support, one, that he didn't receive the booking video, and moreover, that the booking video actually would have contained any exculpatory information that would have been relevant to this case. When looking at the facts of this case, although my brother defines it as minimal, I would state that there were numerous facts that the jury could have convicted the defendant on. There were 3 different marked lane violations that all occurred in roughly half a mile to a mile of each other. When the trooper pulled up next to the driver, he saw that the driver was also texting. And while my brother tried to attribute the marked lane violations to the texting, the trooper was clear in his testimony that it was both the marked lane violations and the texting that were the concern for him. He did not attribute the marked lanes to the texting. Moreover, the defendant admitted outright to consuming 4 to 5 vodka tonics. The officer was able to smell alcohol from the passenger side window, which means it had to have been taking up a large portion of the cabin of the vehicle. He had the bloodshot and glassy-eyed, the slurred speech. He hesitated for over 10 seconds or close to 10 seconds before answering the initial question of the trooper of where are you coming from? And then when he was asked to get out of the vehicle, he said, "Can I just walk home? I live half a mile from here," which I would suggest the jury could infer was him acknowledging maybe he shouldn't be driving right now if he's willing to leave his vehicle on the side of the road at 1 a.m. right off of an exit of Route 1. Moving to the motion in limine argument regarding the reference of the golden banana, I would first argue that it's not preserved. I would say that the defense counsel effectively withdrew his objection when he stated that would address my problem or that would address my concern in response to the judge stating that they would ask a voir dire question specifically aimed at finding out if anyone had particular ill will or preconceptions about people that frequent gentlemen's clubs. So I would say that that statement, it would address my concern, withdrew his objection. But moreover, if it did not, I would say that Grady is clear that it has to be the same content of the objection below as is being raised above in the appeals court. And below, the argument was focused on this idea that it would affect the juror's view of his defendant's morality, that they would assume that he was a bad person for going there. That's not really the argument that's being pursued now on appeal. The argument being pursued here is that it's irrelevant. But even below, trial counsel had acknowledged that the Commonwealth has a right to establish where the defendant was coming from. So I would argue that that was
I
not...
thought the motion in limine said would be prejudicial to the defendant without adding any relevant evidence.
And that was the written motion in limine, so I suppose it is part of the record, Your Honor, but when looking at the actual argument within the trial transcript, that was never what was articulated or the focus of the judge's attention within this motion in limine argument. It was solely on the morality, with the defense counsel conceding that we had a right, or the Commonwealth had a right to prove where the defendant was coming from. And moreover, I would say that it is probative in that it shows his last destination was a place that was serving alcoholic beverages. It's not as if he went out to dinner somewhere and then he went to a friend's house and played video games for a few hours or to a place that perhaps he wouldn't have had access to alcohol. It shows that where he was coming from was a place that he could have been drinking the 4 to 5 vodka tonics. So I would argue that it is probative in this case. And with the voir dire question, any chance of prejudicial value was ameliorated. I don't think that with that question to screen jurors and then with the instructions at the end that they were not to let any subconscious biases infect their deliberations, that there is no chance of prejudice in this case. We screen jurors for much more prejudicial issues, whether it's gang involvement or sexual assaults. So in this case, where a voir dire question was there, I think it was appropriately addressed. And if there are no further questions, I would just rest on my brief.
All right. Thank you both. Counselor, I didn't get a chance to congratulate you last month, but we're very happy to add you to the ranks of our oral advocates.
Thank you.
And hope we'll see you a lot more.
Thank you, Your Honor.
Thank you both. Call the second case, Collins versus Badgett, number 24P239. Whenever you're ready.
Good morning, Your Honors. May it please the Court, Sarah Halpern for Mr. Badgett. We're asking the Court to reverse the order denying the motion for new trial, specifically the motion to withdraw the guilty plea. In this case, there were two motions. The first motion was basically based on ineffective assistance of counsel and some inadequacy in the plea colloquy. After I filed the brief in the first appeal, it came to my attention that the attorney who represented Mr. Badgett had some Facebook postings, and he was actually censored by the CPCS that he was not to receive any appointments for a year, and in addition, he had to present his client with a form that told them that there was a complaint against him. We have details on this form, and Mr. Badgett actually signed that form. Now, the case was then stayed pending the decision in due case. And after that, there was a hearing before the plea judge, and the judge decided that what the court did in due is heavily depended on the direct comments made to Mr. Due in that case, that the posting themselves were not sufficient to find conflict of interest. And there was no allegation in this case that there was a direct comment made to Mr. Badgett. The interesting thing about the Due case is that there are cases, and there are not many cases, and they are from other jurisdictions, not Massachusetts, that categorically state that if a comment is made to the defendant directly, or the comment is on the record, there's a new trial. Those cases were actually not brought to the attention of the trial judge in the Due case. So our position is that that case, the Due case, would have been decided the same way the court decided this, as JC decided the case, based alone on the comments made to Anthony Due. If the court, now I understand that those other jurisdictions, they are not binding authority, but there are a number of other cases that show, and I didn't cite all of them because it's really not specifically issued in my case, that kind of comments, racist comments, comments against a particular person's religion just are not acceptable in the judicial system. So it seems to me that the way the court actually decided to do case, what they specifically say, that you cannot presume zealous advocacy, neutral decision-making, when there is this kind of evidence of racial animus to people of different, whether racist, whether religion, or some other things. So it seemed to me that actually, in some way, the SJC, when they decided to do case, didn't really decide anything new. This is not the understanding, not only of...
The SJC decided not to reach this issue. They decided on the grounds, as you've articulated, that there was specific animus or specific conduct from the attorney to that defendant. And they limited their decision based on that conduct by the attorney. Correct?
They could have decided that if they found those decisions from other
Justice
jurisdictions.
Link wrote a concurring opinion, correct?
I'm sorry?
Cipher.
Oh, excuse me, Justice Cipher? Justice Cipher wrote a concurring opinion in due, correct?
The concurrent opinion says that the posting themselves are...
That's favorable to your client.
Yes, it is. Although in my case, in Mr. Badger's case, there is evidence, and I would suggest very persuasive evidence, that Attorney Doyle didn't provide effective assistance aside from those postings that he was, maybe those postings actually explain why he didn't. One of the things, for example, he filed a motion to suppress. This was at the request of my clients. It was a very important thing for him. He submitted affidavit showing how important this was. His additional lawyer, Attorney Christine Wheeler, supported his evidence, his statement, how important it was. He was very invested in it. He used to send her cases. Look at this case, look at this case, because he also did that to send to me cases. So he's very invested in that. He wanted the motion litigated when the affidavit that Attorney Doyle submitted would have been denied at the request of the Commonwealth because it didn't comply with the rules. The Commonwealth...
Let me ask you this, counsel. How do you reconcile the favorable plea that he got? He was looking at a 10-year minimum mandatory before the motion, and in exchange for not pursuing the motion to suppress, he received essentially half of that.
As a practical matter, we know that the idea that the Commonwealth would not negotiate, even if he lost this motion, we don't have any evidence really that they just wouldn't negotiate, if that was the issue. But it's still his decision. So even if the chances of success were nil, that was his decision to make, not his lawyers. And there's a case, actually, from Supreme Court that says that, specifically. Even in our case, the judge said, the plea judge stated that it would not have been rational. I disagree that it wouldn't be rational because I believe that the motion would have been successful. We don't know. We don't have findings. But
Let me try it this way. I mean, your client's served his 5 years, he's finished his probation. If we reverse, there is a real danger that he'll be tried, get 10 years, and serve another 5 years. Are you confident that this is the path your client wants to take?
Yes. Well, one of the things here is that the whole event would have been recorded because there were recordings of there were cameras, surveillance cameras, and he insisted to his first lawyer that he wants those tapes, that they would show what really happened. And even the grand jury minutes, if you really read them, as I did, read them.
I did as well.
They really show that he was actually immediately in custody. There was a stop because the officers went in front of him. They picked the place where he would be against defense. That's what it shows. And they immediately asked him, told him that they saw him involved in a drug deal. There, in fact, was no drug deal. Nobody had drugs. But that's not necessarily dispositive, but they accusing him, two white officers, accusing a black man of committing a crime, and when he denied it, he didn't have any drugs. When he denied it, they say, you're lying. And the Commonwealth states things like that, actually I find unbelievable. They say that the police observed this other individual who was walking, to a black individual who was walking and making calls. And the Commonwealth says that he was suspected of dealing drugs. They don't know, the police doesn't know him. They don't know that he is a drug dealer, that he is a drug buyer, nothing. And he is suspected. And that's what they state in the brief. And I find that actually terrifying. That in this age, we can say, because this person is black, because there's no other reason. This is 6 o'clock in the afternoon, in the evening.
Well, a guy walks up to a car with money, 20-second exchange. Isn't that a pretty common drug transaction?
They suspected him because he was walking and making calls. And we could actually show that the police, where they were, they couldn't actually even see that. So,
Didn't your client say in an affidavit that they had me in their sight the whole time? Officer Green would have seen? Wasn't that the second affidavit?
that he
I thought your client's in the second affidavit, the officers had him in his sight the whole time. They would have seen any drugs.
the police would have, the Commonwealth tried to say that the woman that was with my client, his wife, that he could have transferred the drugs to her.
They had me in their sight the entire time. Officer Green would have seen if I had transferred drugs from my mouth to my pocket.
He said that he said that the officer said that he put his hand to his mouth. Then he said he could, when he was asked, did he still have money in his hand, he said, I couldn't see, I was too far away. If he could see his hand, he could, I mean, he didn't see a transaction. The Commonwealth doesn't actually claim that there was initially a reasonable suspicion. They just said that it evolved. And I think that the whole of the evidence would show, we don't know for sure what the judge who hears the evidence would have actually found. But we don't know that. But we can't say that he didn't have a chance. I mean, this is one of the strongest, actually, for the defense, motions to suppress. And in any event, it should have been and only Mr. Badger's decision, not his lawyers. And his lawyer actually had an interest, an overwhelming interest, in having Mr. Badgett plead guilty. That's what his interest was. He was now being under, he didn't want somebody to complain about him. And the idea that this attorney, who obviously didn't know the case, couldn't make any decision regarding the motion, would then be, that Mr. Badgett would be responsible for his lawyer not providing an affidavit. What would he have said in that affidavit that we don't know? We know
Counselor,
that he was not prepared to
Before you
try.
run out of time, there's two issues about the probation conditions and the term. And since your client succeeded in probation, are those issues moot? They seem moot to me.
Well, I don't think maybe they are moot. I don't think that they were moot when I filed them.
No, I get that, just now.
Yeah.
No, I understand why you raised them, but at this point.
Yes, I think that it is somehow concerning, not for Mr. Badgett, because he's completed the probation successfully, but that you tell somebody, stay away from some area, and you don't give them specific directions, which is required, how far away from exactly what area. It's not a question that it's hardship or not hardship. This is a sentence. This is not a kindergarten. Maybe it should be hardship. That's not the issue. But it should be clear. So I ask the court to reverse the conviction.
Counsel, on the choice of counsel form, what were does the record contain the circumstances of when the defendant signed that? For instance, was the defendant in custody when he signed that?
I actually don't remember, because I know that he was in custody and at some point he was released, so I didn't actually check that.
Okay.
On that issue, I would say that the Commonwealth said that that's a knowing, intelligent.
Well, that's a different question. Another question about that form, though, is related to that form. Why was counsel appointed after what CPCS had concluded? Do you know?
He was appointed.
Really don't know.
Wasn't he
and
appointed
I would-
before? Wasn't he appointed before the CPCS investigation?
No. He was appointed, well, I think they already knew about it. And if he was, but why did they actually, whether he was up, no, I think maybe he was, I don't know exactly when they knew, because actually I tried to find that out, and I would try to find out what exactly the purpose of this form is, because it negates what it says. It says, I contested, and then Attorney Dahl told my client, those are false allegations. And I don't know what somebody thinks bias is. I mean, everyone has some bias, and I'm sure everyone knows that. And I wouldn't be surprised that the defendant thinks that maybe all white people have some bias against black people or other people. So Did doesn't tell them. Did not tell my client, if they wanted a waiver, he should have shown him those actual postings. That's a waiver. Then it would be a waiver. And I would just say on this point that in due, the court, the SJC disregarded, I would say, what Mr. Doyle, that Mr. Dew actually knew about the prejudice. He was the direct recipient of it.
All right.
So he knew.
I think we'll have to end it there.
Thank you.
Thank you very much. Hear from the Commonwealth now.
Good morning, and may it please the Court. ADA Mackenzie Slyman on behalf of the Commonwealth. If I may, I'll start with the motion to suppress, as it is an issue in both the first and second motion for new trial. At the outset, I would like to first acknowledge that the defendant, when the Commonwealth gave at the plea colloquy of recitation of the facts that supported the plea, after hearing that, the defendant was explicitly asked if he heard what was said, if he did he do what was described, to which he said yes. Do you understand that by pleading guilty, you're admitting that the facts described just now by the Assistant District Attorney are true? Yes. And now to run through those facts that were presented by the Assistant District Attorney, that the officers were in the Lenox Street housing development, which they knew to be a high crime area with drug transaction issues, saw the defendant approach the driver's side window of an individual they had already been surveying, lean in for less than 20 seconds, and come out and put his hand up to his mouth and begin walking away. When they approach him, they ask him if they can speak with him, which he agrees to, says he hasn't stopped for anything, which is clearly belied by their own direct observations of the defendant. When asked if he had anything illegal on him, said he did not have any drugs on him, was nervous, sweating profusely despite it being a cold February day, and repeatedly reaching into his pockets despite being told not to. Continued to state he did not have drugs on him and that the officers could search him, therefore consenting to anything that happens after that. And when initiating the frisk, reached for his waistband, struggled with the officers, and the officers were able to pull a large capacity firearm out of his waistband. So from that alone, where again, the defendant admitted under oath in front of the judge that all of that was true, the Commonwealth—
The purpose of a plea is to plead to the charges before you. He's already given up his right, or as part of the plea, he's giving up his right to contest the charges. So I'm not sure a reasonable defendant would say, well, now is the time I'm going to argue about whether the cops did that or didn't do that. Now I'm just taking responsibility for the crime. So I think it's a little bit different than you're framing it.
I disagree, Your Honor. I don't have the case cite in front of me. It's certainly in my brief that there is consequence to these statements that are made during a plea colloquy. You don't get to just pick and choose when what you're saying, what you're admitting to the court is true and when it's not really true. That, well, I know I said that everything that was just said by the prosecutor is accurate, but now after the fact I'm saying, no, it wasn't. There is consequence to saying in front of the court that what I said, that what was just read to me is accurate. And I would point out as well, in the defendant's two affidavits, they include statements that are directly contradicted by what he's admitted to after hearing what was articulated by the prosecutor. Says that he did not consent to being searched, that he did not make any statement about why he would carry a gun on his waistband, that he was not Mirandized until later at booking. Conveniently, all of the things that he now contests are things that were material to the facts that were presented to the plea judge at that time. And again, framing this as well, it's the defendant's burden to prove that his motion to suppress was meritorious and would have been successful, which he, again, utterly does not do here. Number one, he admits to all of those facts, again, by nature of the colloquy. But number two, his affidavit presented on appeal makes all these statements about about what his wife witnessed and what she would have testified to and that her testimony would have shown that the police were lying. But we don't have an affidavit from his wife. We don't have anything that says he tried to get one from her. So all we have here is the defendant now after the fact saying, I know I admitted to all these things then, but now I need to say that that's not true because it's to my benefit now to say that it's not accurate. So the defendant has not shown that he would have been successful in this motion. Separate to that, though I recognize we did not have receive an affidavit from Attorney Doyle while he was still alive for this first motion for new trial, the case still supports, the record still supports that the decision to forego the motion to suppress, where again, one was filed, the decision to forego it was likely a strategic one. The prosecutor explicitly said that the deal was made in consideration of the defendant pleading guilty that day prior to litigating that motion. That's on page 10 of.
The day of the motion, though, would you argue that counsel was ready for the motion? He didn't subpoena prior attorney. Would you agree she had helpful information?
I'm not sure I would go that far, Your Honor.
It's a little bit odd that she went to visit the authority who had the recordings, and they said they couldn't comply and they couldn't really be clear about that. But on top of her request there was a police card, is that correct? A card with the Boston Police on it?
I believe so. I can't speak definitively
It's
of
unusual.
my recollection at this moment, but I think perhaps, sure, perhaps that attorney could have been called. I don't perceive that to have been, smoking gun evidence that would
And
have.
what about his wife? Had she been subpoenaed for that hearing?
Per the defendant's affidavit, a subpoena was not issued because Attorney Doyle's investigator spoke with her, and she said she would absolutely not be coming into court for any sort of hearing. So there's nothing in addition to that reflects that a subpoena was issued. And again, we have not heard from his wife of whether, that's
But the issue
another
was on
lie.
the day of the motion, he didn't have a subpoena for the wife, which you could have asked for process for if she didn't appear. He didn't have a subpoena for the attorney. How was he prepared for the motion?
Again, it's not borne out by the record because they instead made this decision to go forward with this very favorable plea. I would presume, again, we're in a position of having to assume that because we did not get an affidavit from Attorney Doyle, that it would have been, as in most cases, done by cross-examining the Commonwealth's witnesses and poking holes in their story, or perhaps the defendant himself would have, if he wanted to testify, to say, hey, everything they're saying is inaccurate.
But everything is maybe viewed a little bit differently in light of the evidence of the bias of this attorney. For instance, the defendant says the attorney advised him he wouldn't be able to testify, correct?
Yes, the defendant states that in his affidavit.
In that statement, maybe you don't credit normally, maybe you do. It really depends on the circumstance. You have to evaluate everything. But when you're starting from a point of an attorney who has a clear bias against black people, a clear bias against black individuals with firearms, in a firearm case, maybe you start to look at that a little bit differently. So suddenly now you have a motion where maybe the defendant was told he couldn't even testify.
I accept that is certainly an interpretation and a fair for the motion judge to, for the motion for new trial, to credit that from the defendant should she have decided that he was credible to that contention. From that, I'll circle back to what this court's review here is, whether Judge Donatel, in denying that motion for new trial, abused her discretion. And though a different judge might say, yeah, I do credit, knowing what we know about Attorney Doyle and his bigoted and racist beliefs, that I do credit that he did say that to the defendant, and that might change the analysis. There's nothing that requires that the defendant be credited in that way. And so Judge Donatel not crediting that statement, that he was advised or prohibited by his attorney from testifying, would not be an abuse of discretion on her part of evaluating. Again, the affidavit that he put forth that is completely contradicted by what he, in front of her, admitted was true. And as well, it was a very lengthy colloquy going back to the change of plea, where Judge Donatel went through everything and repeatedly checked in with the defendant to say, do you understand what you're doing today? Have you been adequately represented by your attorney? Do you feel like you have all the information you need? Did you go through the charges? Do you have everything that you need to do this today of your own volition? And at no point did the defendant exhibit any sort of hesitation. So on that point, the defendant has failed to show ineffective assistance of counsel. I'm happy to go through at this time the other claims raised in that first motion for new trial, but if you'd like,
I think you'd best get to the Attorney Doyle issue.
Of course.
time
So
left.
I first argue to you that the posts alone do not do not create an actual conflict of interest. I certainly recognize in that footnote in due that the SJC chose not to go that extra step further, finding that, and I would also say very much emphasizing repeatedly in their decision that the actual manifestation of his views with Mr. Dew made it undeniable that there was actual conflict there. And I think that is the core of this here, is that it needs to infect the representation that the defendant received. Here, at no point has the defendant, in either of his affidavits or during the plea colloquy, stated that he, that there were any negative interactions with Attorney Doyle suggesting any sort of personal bias against him. And I would point out to the court as well, in due, in that, litany of things, of remarks and behaviors Attorney Doyle had related to Mr. Due's prayer cap that he was repeatedly wearing. And one of those instances, he refused to even speak with his client. So that's, an especially poignant point
But
where...
why isn't bigotry against the defendant a conflict of interest, regardless of whether you manifest it?
I would say it's a potential conflict of interest, and then we shift the analysis to whether the defendant was prejudiced by it. And any claim of prejudice he alleges in his second motion for new trial was the motion to suppress that was not pursued.
So why is it potential and not actual?
I'm sorry, can you say that again?
Why is it potential and not actual?
Because I think actual requires evidence that it has infected the representation of the defendant, which has not been shown here.
Why is that?
Why is that?
Yeah, why can't someone have an actual conflict of interest without it showing that it infected the representation? I mean, in federal court, that's how it works, but I didn't think that was how it worked here.
I appreciate Your Honor's question, that it might not be so explicit in our case law that it needs to be, it has not been written as black letter law, that we have that extra extension of it. But the fact that we even have the potential conflict of interest as our second avenue, that we have these two paths of what is a conflict of interest, I think shows that it is, an actual conflict has to be substantial, there has to be not just knowing that someone's beliefs are a certain thing, that it does infect the representation. And we're also in a unique position here with the waiver of choice of counsel form. The defendant was made aware of the investigation by CPCS, that Attorney Doyle was found to be, have an actual conflict per CPCS's investigation. The Commonwealth is not, as I've just argued, not saying that it was an actual conflict, but that CPCS found that he had one, that he should not be representing, ethically should not be representing anyone who's not white.
Well, the choice of counsel said he had a bias, and as counsel said, maybe Mr. Badgett said, well, all people are biased. He's going to sign this. Mr. Badgett didn't know what Attorney Doyle had put on his Facebook, the depth of his bias.
Sure, and it would certainly be a stronger argument for me if we did have that the Facebook posts were provided with this choice of counsel form to the defendant. But the substance of the form had sufficient information for him to evaluate whether or not I should stay with this person. And again, it had that CPCS said that I should not ethically represent you. So it's not just I have a bias against you, but that, that the organization that appointed me to represent you on this case thinks that I shouldn't. I'm contesting this. I don't believe in these allegations, but you, and it's made clear as day to him, you are welcome to have a new attorney appointed to you. You will not be held against you.
This choice of counsel, sorry to interrupt you, this would have been a lot stronger from your perspective if there had been an actual colloquy. Was it not your office's perspective at that time to ask the judge to conduct a colloquy at this point?
I can't speak to what our office's policy was. That I think this came up when my sister was arguing that it is a pretty tight timeline here of how these events took place. So I can't speak to how many of these waivers were executed and whether we were asking for colloquies on any of them. Looking again quickly at the affidavit from the investigator with CPCS, that investigation was instigated in September of 2017, the same month that Attorney Doyle was appointed, and then this choice of waiver of counsel form was signed in December. So we're talking 3 months later. So I assume this was kind of just being rolled out at that time, but I can't speak to whether.
Do you happen to know when the CPCS investigation concluded with its finding that he was, guilty is not quite, but you don't understand what I mean.
Yeah, I was, again, reviewing the materials from the CPCS investigator. I was not able to, in my quick scan of it today, see if there was a final date. I know she signed her affidavit in 2021, but obviously temporally here we know that investigation concluded in some way prior to December when this waiver of counsel form was executed.
Do you know when the last postings were made that were investigated?
I believe they were in 2017, that it was a period of 2014 through 2017.
The same year that Attorney Doyle was?
Yes, yes.
So does that, the fact that the postings were essentially contemporaneous with representation, does that impact our view of whether there was an actual conflict?
I don't think it does. Again, I think it's certainly closer in time to other instances where, and I did put in a footnote, I recognize a panel of this court in deciding at Commonwealth versus Maines with representation that happened a couple years prior found that there was actual prejudice. We're certainly closer in time here, but I don't think that closeness in time, again, requires an actual conflict to be found where there has been no suggestion or no evidence that this infected the defendant's, Doyle's representation of the defendant. And in fact, we are in, again, another unique position here where we had Judge Donatel review that first motion for new trial before due came out, before we, had this greater understanding of Attorney Doyle's biases, reviewing it as any other attorney, whether they provided effective assistance, and there she found that he had. So, it's almost an elevated review that an unbiased attorney provided effective representation.
All right. Counsel, can I ask you to do one thing? There's a mention at the hearing about a police report the Commonwealth attached to its opposition to the new trial motion, and I didn't see that in the record. If you could dig that up and submit it to us,
Of course.
that would be very helpful.
Of course. Thank you. If there are no further questions, I will rest on my brief.
All right. Thank you both.
Thank you.
It's an interesting case. We're very appreciative of your efforts. I'll call the third case, Commonwealth versus Thabu, 24P 652. Whenever you're ready, Counselor.
Good morning, Your Honors, and may it please the Court. Nick Madison for Mark Tebow. Courts of the Commonwealth have long recognized that self-defense instructions are sensitive parts of jury trials and that errors in them can readily lead to miscarriages of justice. And that's exactly what happened in this case, where the instruction on self-defense communicated to the jury that it had to make certain findings before holding the Commonwealth to its burden of proof to disprove self-defense. These instructions lowered the Commonwealth's burden of proof, and counsel was ineffective for failing to object to them. For these reasons, as well as a separate incidence of ineffective assistance arising from counsel's failure to obtain the criminal record of an alleged victim, a new trial is required in this case. Turning first to the self-defense instruction, the trial judge correctly found that the evidence here raised the issue of self-defense. And that created an obligation to clearly instruct the jury on the Commonwealth's burden of proof to disprove self-defense. And in this regard, the instructions failed, were deficient. The instructions contained two separate but related errors. First, it explicitly conditioned the Commonwealth's burden to disprove self-defense on the jury making certain findings. And this was clearly did not accurately state the law of self-defense, because if the jury holds a reasonable doubt about self-defense, the defendant is entitled to an acquittal. It need make no findings as a predicate to holding the Commonwealth to that burden.
Wasn't the reference to if you find, I mean, it was just a reference to however you view the evidence, right? It was simply a reference to the jury making certain determinations as to what they believe in the evidence, and that will determine whether the issue of whether they, right? It was just a reference to that the jury could have believed certain evidence or disbelieved other evidence, and so it depended on what the jury believed.
I would respectfully disagree, Judge. I think there's two incidents here, one of which the instruction said the defendant claims has claimed self-defense here, and if you find that there's evidence of self-defense as the defendant has claimed, then you must go to hold the Commonwealth to its burden. That's, I think, different, and certainly the second one where the Commonwealth said, if you find that any force the defendant used, he used in self-defense, then you must go to hold the Commonwealth to its burden. That's something different than saying, you, the jury, determine what the facts are, and
I mean, that's one way of reading the second thing. You could also read it as going back to the first one, which is that if you believe any force was used at all. I mean, why wouldn't a jury understand it as the second one? I'm not talking about the third one. Well, the second one you're claiming, the last one. Why wouldn't a jury understand that as going back to the beginning when the judge said, if you find force was used at all? Which, of course, was at issue here, except for the push, whether the stick was used at all.
So the self-defense, the defenses as presented were that the defense counsel argued that the stick was never used and that the video supported that the stick was never used to strike Frank Chaparro. As to the pushing with a bare hand, that counsel, upon review of the video, thought that the only defense of that was self-defense. And so in the context of this case, whether any force was used was essentially conceded and supported by the video. And so it was, I don't think that was particularly in doubt in this case.
But this instruction had to work for both, right? I mean, it had to work both for the stick and for the shove.
The self-defense charge?
Yeah.
Well, as the defenses were pursued, the defense was there was no touching of the stick, and so self-defense was not required there because there was no battery. As to the shove, where there was...
Right, but for the judge instructing, the self-defense instruction has to do the duty of handling the stick allegation as well, right? I mean, it was given to the jury, right?
I suppose that's true. It was a general self-defense instruction. But these instructions as phrased, if you find that any force was used in self-defense, is different than saying if you find that Mr. Thibault contacted or there was force used by Mr. Thibault, then you must go on to hold the Commonwealth to its burden. That is...
I get they're different, but how could a jury understand this as saying, if you find that he acted in self-defense, then the Commonwealth has to disprove that he acted in self... I mean, it doesn't really make sense, where if you understand it as if you find force was used, you have to find the Commonwealth acted in self... Again, I'm talking about the last one, not the middle one.
I think Connolly gets into this a bit, which it suggests that it is unclear exactly what the jury was trying to do. The jury likely could have tried to harmonize all these into one rational thought, one rational line of inquiry. What Connolly says is instructing a jury that they need to that the defense is raising a claim on which the jury is required to make findings, suggests to the jury that there is some burden, an unclear burden. This is what Connolly says. They might have assumed that, or they might have rationally believed that the defense had to come forward with some sort of evidence on which the jury had to make some sort of, perhaps a preponderance showing on that evidence before holding the Commonwealth to its burden. And because it was unclear but suggested a unclear burden, there's a likelihood that the jury, particularly in this context where Mr. Thibault did not present evidence in his case of chief, he relied on the testimony admitted during the Commonwealth's case and the video which was admitted during the Commonwealth's case, that the jury might have heard that you have to make findings based on whether or not there was evidence of self-defense as the defendant claims, and as to whether any force the defendant used, he acted in self-defense. that he didn't meet that threshold because he didn't present any evidence in this case. That confusion combined with, and this is the second error arising from these instructions, framing the defense as a claim on which the jury must make findings already suggests a burden that the defendant has to meet as to this defense. This is discussed in Vedito and Rodriguez, that the finding and claiming language is problematic. When you combine the two, you get a synergistic effect suggesting that the defendant has some burden. I agree with Your Honor, it's not exactly clear how all of these instructions are supposed to work together, but it suggests some burden on the behalf of the defendant, which is contrary to self-defense law.
But there's no language suggesting that anyone has a burden, simply pointing out that the evidence has to be available to you. And it's evidence that you credit, then you move forward. And that's correct, isn't it?
So the jury has to make determinations on what the facts are. Having made those determinations on what the facts are, the juries apply the reasonable doubt standard as to the elements, or in this case, as to disproving one of the predicates of self-defense. So using that finding and claiming language in addition to the conditional language removed the jury's focus from, if you have a reasonable doubt on these predicates, you must acquit, which is the law of self-defense. The suggesting that you have to determine if there was contact or if force was used in and of itself represents a lessening of the burden, because if the jury had a reasonable doubt about that, they still have to acquit pursuant to the established standard of proof for self-defense and the Commonwealth's burden. I would just suggest briefly that the conditional language in combining with the finding and claiming language lowered the Commonwealth's burden, and that the video here represented substantial evidence of self-defense. And because the likely effect of these instructions was that the jury may not have held the Commonwealth, and likely didn't hold the Commonwealth to its burden, that this error represented both a substantial risk of a miscarriage of justice, and for the same reasons, counsel's failure to object to it prejudiced the defendant. Turning quickly to the failure to investigate, the Commonwealth doesn't seem to have contested that the failure to obtain the criminal record of an alleged victim would constitute deficient performance. And that's for good reason, because obtaining the criminal record of the alleged victim, not just any witness, but one of the alleged victims, is one of the most basic investigations that any defense counsel would conduct.
Perhaps that wasn't an issue because the victim didn't testify.
He did not end up testifying, but as I note in my brief, obtaining the criminal record of an alleged victim is a predicate to discovering all sorts of trial defenses, as applicable to this case, adjutant material, but also potential motives to fabricate if the defendant had any pending cases in which he was trying to, he might have had an incentive to curry favor with the Commonwealth, and impeachment material like prior convictions. So the fact that the defendant didn't end up appearing at trial to testify doesn't take away from the deficient performance, where getting the criminal record was necessary to make intelligent choices about what defenses to pursue at trial. And also in the case of adjutant, adjutant material needs to be disclosed shortly after the pretrial hearing, If you haven't done that investigation, you can't disclose it at the required time. So for those reasons, whether or not he testified, the trial
So it wasn't clear to me what the actual adjutant evidence was that could be admitted at trial. Could you walk me through it?
Certainly. So there was a prior conviction for assault and battery with a dangerous weapon resulting from an interaction with.
And you think you can get the conviction just in?
I think the conviction, in addition to either the Commonwealth's statement of the case, which is appended in the
So why would
appendix.
a Commonwealth statement of case be admissible?
As to
Get that.
as to the facts that the defendant admitted to in the course of pleading guilty, or alternatively the facts listed in the plea colloquy. But in addition to that, you also had several restraining orders, the affidavits of which supported frank escalating.
It's like, again, you couldn't get the affidavits in, right?
You couldn't get the affidavits in, but the affidavits would have been admissible if the witness had testified inconsistently with.
Right, but he wasn't going to testify at all. It's like, I understand when you've got a conviction or an affidavit and you got the person actually testifying, you can ask them, didn't you do this? But when the guy's not testifying, that's what I'm missing. There's like one where David's the victim, so sure, you
Yes.
get that in, but the other ones, I just wasn't seeing what the strategy was to get them in.
Well, I mean, this is again framed through a failure to investigate. Counsel didn't call these witnesses to appear because she didn't know about the restraining orders that could have been presented. If she had used process to summon these people in, and they had testified inconsistently with the affidavit would have been substantively
To get win a new trial motion, don't you have to show that those witnesses are available and would say that, as opposed to just say maybe they would, maybe they wouldn't?
In the case of an affidavit signed under the pains and penalties of perjury, either they would have had testified consistently to it, or the affidavit itself would have been substantively admissible, which by a reasonable likelihood establishes.
Why is that?
I'm sorry, Judge?
Why would an affidavit be substantively admissible if the person comes and testifies differently?
As a exclusion from the hearsay rule, affidavit submitted under 209A becomes substantively admissible under Commonwealth v. Belmer, I believe it is.
Well, where'd you have a save for that? I'm not familiar with this.
78 Mass App Court 62, which is a 2010 case. And seeing my time has expired, I would rest on my brief. Thank you.
Just a sec. All right, whenever you're ready.
Good morning. May it please the court, Allie Bockhart on behalf of the Commonwealth with ADA Aaron Knight, asking this court to affirm the defendant's conviction. Your Honor, the trial judge's self-defense instruction to the jury was proper, and there was no substantial risk of a miscarriage of justice here. We review this error under a substantial risk of a miscarriage of justice, as the defense did not object to the instructions when given the opportunity to do so. There was no substantial risk of a miscarriage of justice here because the defendant wasn't due the instruction in the first place, and there was no error in the instruction. I would argue that the defendant wasn't due the instruction in the first place because he, in fact, here was the first aggressor. As seen in the video, which was made available to you and played during trial, he was the individual who started the argument, and he was the first person to leave the argument, obtain a weapon, and then come back with that weapon.
How can you tell that he was the first to start the argument?
When in the video, when he's walking by the two men by the by the yard. As he's walking by, there was testimony from Daniel that he was insinuating that he wanted to see a fight, and that was his.
Oh, I thought you were saying from the video itself you could see this.
Oh, well, I would argue that his first sign of aggression was him grabbing the stick and then coming towards the two men. So I would say that that was his first form of aggression when he was heading towards the two men with the stick, is what I would say. But he also was the first person to kind of involve himself or insinuate that he wanted to see a fight happen, and then that's when the situation kind of escalated. But yeah, as seen in the video, the defendant has words with the two men. He then leaves the two men, goes around the corner of the building, and then comes back with a large stick. And he's the first person ever to grab a weapon. The defense, in their brief on their claim of self-defense, makes statements makes the claim that Daniel, who was the victim's brother in this case, he was actually the first aggressor, and he brandished the cane at the defendant or held the cane in the air. But the specific time that the defense references to in their brief to support that claim, when you go back and watch the video, the victim's brother is actually using a cane to assist him in physically walking down the sidewalk, and it's only with his finger and with his hand that he's pointing at the defendant. At no point during that specific time that defense references is he holding up the cane. He only holds up the cane after the fact that the defendant has then came around to the other side of the building and is like heading towards them with a stick. That's the only point. So I just wanted to make that distinction because the defense in their brief rearranges the series of events, and just like the instructions in this case, you have to view the video in its entirety and see the escalation. In regards to my second point, as there was no error in the instructions, Commonwealth v. Owens establishes the standard that you view the jury instructions as a whole, as well as Commonwealth v. Marino. When you look at the instructions as a whole and as a reasonable juror would, you can see that there is no error in these instructions. It's not required that judges use particular words, but only that legal concepts are properly conveyed. And now, although the instructions were not verbatim of the model instructions, they accurately conveyed the legal concept of self-defense.
Maybe it's not error, but it seems singularly unhelpful to tell the jury, if there's evidence of self-defense, then do this. Wouldn't you agree?
When reading that sentence, I viewed it as the judge kind of establishing a checklist for the jury. She's not making any findings that the defendant was entitled to the self-defense claim. She's just illustrating that if you find that he acted in self-defense, then this is your next step in the analysis. It's the judge's discretion to give the instruction, but then it's the jury's duty to then find if he acted in self-defense. So I viewed that sentence as her establishing a checklist for the jury. And then even when you look at that specific sentence, the direct sentence after is that if the jury has any reasonable doubt, if the defendant I'll actually say the exact wording. She says, if you have a reasonable doubt whether or not the defendant acted in self-defense, your verdict must be not guilty. And then even in the subsequent pages beforehand, she stresses that the Commonwealth has the burden here. So she kind of bookends that sentence with correct self-defense instructions, I would argue. So I would argue when you look at them as a whole, as a reasonable juror would, it's clear that the instructions didn't contain any error. And then just to point to the last claim that defense counsel pointed to in regards to trial counsel being ineffective, I would argue that the defendant claims that trial counsel claimed to obtain criminal history of the victim, and claims that the victim's criminal history could have came in through impeachment evidence or as adjutant evidence. It couldn't have come in through impeachment because the victim actually didn't testify at trial. So,
But you can impeach a hearsay declarant, right?
Yes. But I would say that You can, but here, I don't think even bringing in the criminal history would have made a difference, because if you look under adjutant, which is the second point, is that the video is everything. The video clearly demonstrates that the defendant was the first aggressor here, and even if you brought in the victim's criminal history, it wouldn't have changed anything because you have clear other evidence that the defendant was the first aggressor. Because adjutant evidence is only when the identity of the aggressor is at issue, and here that's not at issue. And even pointing to the 16L letter that we filed yesterday that touched on the point that adjutant evidence is supposed to be really used when there's no other evidence of the altercation, and here there's clear video evidence that demonstrates that the defendant was in fact the first person to grab a weapon to display any sort of aggression and then use that weapon, or use his aggression towards the two men. And unless the court has any other questions, I rest on my brief. Thank you.
All right, thank you. Always great to have a law student arguing here. You know that clerkship applications are due this summer. Just something to think about. And I thank you all,
Thank you.
both of you. All right, I'll call the fourth case, Tropical Phase 2 LLC versus City of Boston Zoning Board of Appeals, number 24P 1019. Whenever you're ready, Counselor.
Good morning, Your Honors. Scott Ford for the plaintiff appellant in this matter. Tropical is arguing that the land court made errors of law and also committed clear error. We're arguing that the land court made a clear error when they found that Tropical's expert report evidencing harm from traffic and parking to Tropical's and others' common parking and access area was speculative. We are arguing that the land court made an error of law when, based on the facts in this case and how this property is physically put together, Picard specifically does not apply. I think it's important for the court to consider the procedural posture of this, and I think there is a confluence of the uniqueness of zoning law and motions to dismiss under 12b1 for subject matter jurisdiction, and also just having in the back of our mind summary judgment issues. So the city brought a motion on subject matter jurisdiction, and the court conducted an inquiry, and the city basically argued that Tropical lacked standing as a subtenant of the adjacent property and made some vaguely generalized concerns, was their argument. And we know under Wooten that on a motion to dismiss, 12b1, there isn't the typical deference that you'd get on summary judgment. But Tropical did offer expert testimony. We presented Dr. Mark Warner. He holds a PhD from MIT and is a specialist in transportation and the impacts of construction projects. For the city to argue that these were vague generalized concerns, I don't think the city has produced any affirmative evidence that to the contrary. The characteristics of this property here are unique. This is not a single homeowner complaining about parking in front of their street. This is not a building owner in a commercial setting complaining that an adjacent property is going to have some sort of economic impact on their building. This is a city block that, for all intents and purposes, I would submit to the court, and there's evidence in the brief, essentially functions as a neighborhood. This is a very familiar area, I'm sure, to the court, the confluence of Washington Street and Melnia Cass. There is a commercial supermarket, that is the plaintiff in this case. There is retail, I believe some retail and office space located on Washington Street, and there is this parcel that is slated to be developed into the 10-story building that's the subject of this dispute. The access to all of those parcels comes through a shared use agreement, meaning all the traffic coming to any business, any public purpose essentially to get there, to use those businesses, to shop. There's even some evidence that there could be a public space contained within the development, has to come through these access points. There is traffic coming into these access points. There are deliveries, and so on and so forth. Tropical also has 91 exclusive spaces. And Dr. Warner opined that visitors coming to the proposed development will find, in his expert opinion, will use short-term parking solutions.
Counselor, it seems to me there's two problems. And the first is that your own expert basically says that generally 40%, 30% of the spots are empty right now, that there's parking in the neighborhood too. And, every once in a while, almost all of them are full, but generally most of them are empty. So where do we get that these extra trips? I mean, your expert makes a strong argument that the people in this new building are going to have a serious problem. But where do we get harm to your client from your report?
Well, I think we get harm from, again, going back to the procedural posture, this report was put together in January or February, I correct myself. There is an affidavit from the owners of Tropical Foods that the spaces that they have right now are barely sufficient to operate the business. Supermarkets are cyclical.
Can we take a conclusory statement with that compared to an actual traffic expert who shows that you never average? I mean, basically your traffic expert proves that's false, that it never even hits 70% as average capacity use.
I disagree, Your Honor, and I think the traffic study was done at a time of year where the usage of the supermarket is not at capacity, all right? And for Tropical to have a problem, it doesn't have to have 100%, because supermarkets are a cyclical thing, certain holidays, certain times of the year. More people go at different times than others, and you need to have a parking lot sufficient for the maximum amount of use that they could see. But again, I think going back to procedurally, to survive the motion to dismiss for jurisdictional purposes, Dr. Warner's affidavit should be sufficient to survive that. And regarding the speculation argument, Dr. Warner did find that people are going to park in Tropical's lot. So there is actual harm. That is his expert opinion. And there's nothing else in the record to countervail that.
Why is that harm?
To park in the...
Yeah, why is that harm that someone parks in that lot?
Well, Tropical has an obligation to monitor the lot, and you have to spend time and effort, employees or money hiring people to monitor the lot. You can't allow scofflaws to just go unchecked. So now you have to monitor it for parking infringements, and the building that is proposed is so large, it's double the height that would be permissible. There's 96 units. It is reasonable to say that this much larger building that could have been built but for the variance, for the height, is going to increase the amount of parking scofflaws that Tropical otherwise would have had. Again, this is a situation where had the court allowed the case to proceed forward, these are exactly the types of things that would have been recognized and examined on summary judgment after the record is fully developed. But what we're doing here is essentially, because of the confluence between zoning and jurisdiction and proving harm, that opportunity is not being afforded in this very unique situation. And I don't think that should be the intent of what we're trying to do in terms of proving whether Tropical gets over the hump to then pursue discovery and fully develop these claims.
Counsel, is scofflaw parking, is that a harm recognized? I mean, the remedy is to
Under
tow.
zoning?
Well, the remedy is to tow here, so they wouldn't be at capacity, right? So
That is a remedy. I think scofflaw parking is recognized as a harm. Obviously, certain parking infringements can constitute harm. I think Tropical situation, again, going back to the specifics of this development, where it is a large, multi-purpose commercial and residential and business setting, all using the same access and parking easements, it's not the same as someone who's sitting outside of their house saying someone is parking on my street. It's not the same for a couple reasons. The sheer volume of harm potential, and number two, when a person has an availability to call the city or the parking enforcement officer and say, there's someone parking on my street without a sticker, that ends their burden. That's a much different burden for Tropical, who has to monitor the lot or pay someone to monitor the lot. And it's a very difficult thing to monitor the lot for customers. There are issues where, from a business standpoint, a business has to decide, do I want to start towing cars? What if your car, or what if my car was one of those cars in the parking lot, and I come out with a full bag of groceries and the car is gone?
How is the judge supposed to know what the cost of the business of monitoring the lot is? I didn't see that in the record.
It was not developed at this point, Your Honor. That argument was made to the court because of the stage of the proceedings. So early on a 12B1 motion, that it was being gathered but was not, it wasn't fully fleshed out. I mean, we would have loved to have gone back and taken parking numbers at times that weren't February, when it's cold and, you know, perhaps people are staying in or shopping at different times. And that's all things that should have and would have been able to have been developed had this case proceeded through discovery. And then we would be having these arguments perhaps before the land court on a much more fleshed out, fully represented record. And at that time, Tropical will be entitled on summary judgment to reasonable inferences. So what we have here is, it's a short circuit of Tropical's day in court. But we did present expert testimony. It was Dr. Warner's opinion that Tropical will be harmed. And at this stage of the proceeding, not this stage, but at the stage that came out, that should be sufficient to establish standing to then pursue. Most of the cases that are cited are all on summary judgment. I could not find, I tried, find a case that we had lost, that a butter claiming aggrievement had lost on standing at this stage on a 12B1 motion. And I think because of that, the record, all good questions from the court, was not able to be fully fleshed out. So I think for the court to have found Dr. Warner's report speculative without anything else is clear error. I mean, even when we give the land court a reasonable inference from the report, Dr. Warner still says that there will be impacts. Even in the same report that he says that, you know, the parking lot is only full, you know, of the 40, 50% of the time, up to 70%. If he notes that and says, but despite that, there's still going to be impacts, then I think that is, to find otherwise is the definition of speculative, especially when you bolster that expert report from Dr. Warner with Tropical's affidavit that the parking they have now is not sufficient, which was the evidence before the court. Turning next to the additional arguments of clear errors of law, we believe that the land court misapplied Picard, or there should be an expansion of Picard. You know, this court is allowed to review errors of law de novo, and I think on this record this is an opportunity to look at how the development is physically constructed, and recognize that in these situations it makes really good sense to allow an abutter who's part of this development, who is party to agreements with the developer, to bring to bring challenges to zoning decisions that directly affect I don't want to say municipal lot in the sense of ownership, but a public lot that is shared by multiple entities, all living, working, and playing in the same geographic area that essentially functions as a neighborhood. And those impacts are from traffic in and out, and I address the court's concern and raised by my brother in the brief that there are no traffic reports, in essence, concerning traffic in the surrounding neighborhood. This isn't a traffic concern of traffic on Melnia Cass or traffic on Washington Street, both very busy streets. This is traffic pulling into and out of this joint access and parking area. All of the traffic rather coming into the parking garage that's going to be proposed there, but also all of the traffic coming in for visitors, dropping residents off, all of the traffic that's coming in for packages being delivered, ride share issues of Ubers coming in and out. That's all traffic moving in and out. And in addition to that, there are instances, as Dr. Warner points out, that cars will park in that area simply because of human behavior and it is convenient, despite the fact that there may be parking on the street down the road. But human nature is if I'm just running up to my apartment, drop off a package or something like that, people are going to come in and they're going to park, and that is a burden to Tropical. Not all the time, as the court points out, but sometimes it is going to be a burden to them. And again, that is sufficient to survive a motion to dismiss, and it is also a harm that Picard should be distinguished from in this situation, because Picard was just a private easement, and the homeowner didn't want to block the access there, and the servient estate, or the dominant estate rather, was still going to have their access over it. This is a much larger and much more complicated situation, and I think the court in Picard recognized that to a certain degree when it said that in the circumstances of this case, those facts claiming injury to a private easement right was not sufficient to confer standing. I think this case is different.
All right, thank you. We'll have to leave it there.
Thank you.
Good morning, and may it please the court. My name is Paul Commoners. I represent the private defendant, Madison Trinity 2085 Development, LLC, joined in the courtroom today by Catherine Walker, counsel for the ZBA, which joins our brief, and my colleague Carlos Resende. I'd like to start by emphasizing what is actually at issue in this appeal. Although Tropical has just raised a number of objections to the fact that this was decided on a Rule 12b1 motion, there's no actual dispute about the standard of review. And there's no dispute that the land court's factual conclusions are subject to clear error review. None of the arguments Tropical just made about the timing were raised in its brief, which was entirely focused on one issue: how to read Picard v. Zoning Board of Appeals of Westminster. That's the only issue squarely raised in this appeal. It's an issue this court doesn't need to reach, because the land court independently concluded, as a matter of fact, that Tropical's grocery store will not be harmed by this development, especially as a few hundred new customers associated with this development are dropped on the grocery store's doorstep. Those findings were subject to clear error review. They were certainly supported by a reasonable view of the evidence for all the reasons that Justice Ditkoff was pointing at in his questioning. And Tropical has barely challenged them with anything more than an assertion that their expert should have been credited, and now at oral argument that it was too early to decide to discredit him. Because those findings, those independent findings of fact can be affirmed, the decision below can be straightforwardly affirmed. If this court reaches the legal issue of how to read Picard, the land court was correct. Picard, especially in combination with the case Pobeda Route 2 v. Zoning Board of Appeals of Watertown, which came out maybe 4 days before the land court's decision in this case, stands for the proposition that Tropical's private economic interest in a private parking lot is not within the public interest protected by zoning. Tropical has argued on appeal that this is effectively public space within the public interest. Again, that argument was not made below, and moreover,
I don't understand why the use of the parking lot isn't a just ordinary density concern that is squarely within the variances here. I mean, forget the easement. Even if they had no easement, it was just a lot. I don't get that. And this is a very good land court judge, so I feel like I must be missing something.
I think particularly in a case where the project was subject to Article 80 review. Article 80 review is a process, it's the equivalent of an extensive site plan review run by the Boston Planning and Development Agency, where for projects in the Roxbury Neighborhood District, the BPDA sets the amount of parking required by the project. After knowing everything else about the project, including its massing and its intensity of use, the number of residences here. We would say that the fact that the BPDA, first of all, the fact that the BPDA sets the amount of parking under the zoning bylaw in the first instance, after knowing the massing, cuts off any interest, any protected interest in the development having more parking.
Well, I don't get that. He's suing Boston for permitting this building, and you're telling me that he can't do that because Boston said the building's okay. That doesn't really seem to connect.
So there are two independent permitting decisions. There's the BPDA's decision and the subsequent variance decision. The BPDA's decision is appealable. Like any site plan review decision, it can be taken up to court. I have a citation for that. It is not in my brief because I did not anticipate answering this precise question.
I would like that if you could 16-0 that, because that's important.
I don't have the, I do not have the reporter number, but it's St. Botolph, B-O-T-O-L-P-H, Citizens Committee v. BPDA.
Why don't you send it to us in a 16-0? Without the citation, I'm not going to be able to find it.
Yes, yeah, of course, Your Honor. So they could have challenged the amount of parking called for in the BPDA's decision by appealing the Article 80 decision alongside the variances. Having allowed the BPDA's Article 80 decision to stand, that cuts off any direct relationship between the violations of the zoning and the injury asserted. And that leaves, at best, an argument that the Boston Zoning Code indirectly protects Tropical's private parking against a massing and density-based injury. There, I would come back to Picard and Poveda Route 2, which both, in different ways, make clear that private economic interests are not protected by zoning, at the very least, unless the plaintiff can identify something very specific in the zoning bylaw that creates a private interest. This private parking for customers of a grocery store is a private economic interest, and that's clear in how Tropical argued the case below, where in its interrogatory responses it connected the value of its business to the use of the parking spaces, and it's clear here where it appealed the land court's decision as to property values only insofar as property values are derivative of the availability of parking. To show that these private interests are protected, Tropical has never pointed to anything more than general statements of legislative purpose at the very beginning of the Boston Zoning Code and in the enabling act of the Boston Zoning Code. These are precisely, and in the case of the Zoning Enabling Act, somewhat less than the kinds of general statements of legislative purpose that were expressly held inadequate to generate.
But the purpose of an FAR requirement has to be density, right? I can't imagine what else it would serve.
It does protect, it does work in conjunction with a height requirement to protect against excessive height. FAR, you could build tiny and as high as you want. I mean, that's how FAR works, right? Again, in conjunction with height requirements.
Oh, I get it. I get what you're saying, yes.
And in conjunction with setbacks, There are enough moving parts here, including a rear setback variance, which you would think protects against density, if anything does, that Tropical has not appealed, does not even mention in its affirmative brief to this court. There are too many moving parts for the court to conclude that there's a protected interest, especially when, with full knowledge of all of those moving parts, and as expressly delegated to it by the Boston Zoning Code, the BPTA has made a determination about the appropriate amount of parking for this project. So I would like to go over the facts the land court had in front of it. On parking, as Your Honor noted, there was a parking report that showed that for 20 out of 24 hours of the day, this parking lot is below 50% utilization. For 24 out of 24 hours of the day, it was of an average day, it's below 70% utilization. Tropical asserts here, as it asserted at oral argument for the first time in the land court, that the time that they took the parking counts was a low-use month. None of that is in the record or supported by record evidence. It could have been in Mr. Gary's affidavit. It wasn't. The Warner report also says that there is sufficient curbside parking within 5 minutes to serve this building. Tropical can tow, which this court specifically noted in Harvard Square Defense Association, is evidence against the finding of an injury to a private interest. The land court also had in front of it the parking management measures and the fact that my client plans to implement, and the fact that resident parking is available on neighborhood streets for residents of this building, both of which are set out in the affidavit of Josh McLinden. Against that, the plaintiff's assertion that the court had to credit the conclusion that an unspecified number of users associated with this development, plus users from other buildings in the neighborhood, would sometimes decide to advantage themselves of Tropical's parking with sufficient frequency during times when the parking lot is on the verge of being full to materially affect Tropical was not something the land court judge had to credit, and certainly is not something, and certainly his decision to discredit that conclusion was supported by a reasonable view of all of the parking evidence in front of him. On traffic, he had the fact that the Tropical's traffic theory is entirely downstream of its theory that there will be so many more people trying to park in its lot that it will experience meaningful incursions. That connection is drawn in their interrogatory responses, which are also attached to the McLinden affidavit. He also had in front of him the fact that the current overflow lot actually has more spaces than the building that our client is planning to build. So if this is an intensely used parking lot, we're likely to generate fewer trips into and out of our parking lot than the current overflow lot invites. He also had the lot layout, which shows that the most efficient way to get to the parking area that will be in the development passes by very few of the spaces that Tropical will ultimately rely on. I do want to respond briefly to the assertion about burden. Justice Didkoff, I agree, there is nothing in the record actually articulating the degree of burden that Tropical would have experienced. The argument that it was simply too soon for Mr. Gary to explain to the court what kind of parking enforcement measures they currently take, how often he or his employees go out to check on cars, what kind of staff time it consumes. It doesn't hold up. They had time to commission an expert report and take a month's worth of parking counts on this lot. The case was originally filed before transfer to the land court in June of 2023. They filed their oppositions in February of 2024. That was certain, and they had time to pull together an affidavit from Mr. Gary. They had enough time to paper up the burden that they experience, that they claim to experience when,
But the project increased in scope quite dramatically, didn't it?
yes, Your Honor. I don't think there's any dispute about that. They have sued us separately for breaching the development agreements in Superior Court. There's some interplay between those two cases, as we noted in our brief. But we would say that the change in project scope is at most a matter for contract, not a matter for zoning. And insofar as it's a matter for contract, I would add that the point of the contract is to protect Tropical's ability to run a successful grocery business on this site, which my client absolutely wants. We supported them through financing. We would not have partnered with them in this development if we did not want, in the development of these 3 buildings, if we did not want them to succeed. The land court's findings that Tropical will not be harmed by this development indicate that Tropical will get what is entitled to under the contracts, the ability to run its grocery store successfully, maybe with a few hundred new neighbors at 2085 Washington Street. Ultimately, to prevail here, Tropical needs to show that the land court judge made both a clear factual error and a legal error as to either traffic or parking. On the facts, they've only raised 2 cursory arguments that amount to nothing more than a complaint that the land court judge did not credit their experts' conclusions. That does not meet the high bar for clear error. If you reach the issues of law, you'll find that Tropical has completely failed to show that its private parking is protected by the Boston zoning code. The land court's decision should be affirmed, and the variances required to let this affordable housing development proceed should be upheld. If there are no further questions, I rest on my brief.
All right, let me say 2 things. One, I very much appreciate you both including the information about the other case, so we understand what's going on. We didn't have to search it down, which we always could, but it's really helpful to just have it in there. It saves us a lot of time. And finally, Counselor, I couldn't believe this was your first
Yes, Your Honor.
argument here. I checked it twice because I couldn't believe that. So congratulations and welcome to our ranks. With all that said, thank you both for this case. It's submitted. We're going to take our break now. It will be no more than 15 minutes. It might even be 10 minutes, so don't go too far.
Thank you, Your Honor.
session, please be seated.
All right, back in session. I'll call the next case. UBS Financial Services Incorporated versus Matten, number 24P 748. Whenever you're ready.
Thank you, Your Honor. Good morning. My name is Thomas McMillan, and along with Attorney Kristen Usanka, who is at council table, represent the individual named Thomas Matten, who is in this case both individually and now as a result of his mother's passing, he's also the personal representative of the estate of Bernadine Matten. Now, one of the first things I'd like to address before we get into some of the main parts of the argument that we've raised in our brief is why, given the declaratory judgment and instructions in this particular case, why an appeal would have been filed. Well, as noted in the record appendix, both in the judge's finding, the guardian ad litem's report, in addition to a memo which was submitted as to a status report filed by the UBS counsel themselves, there is a companion case existing in the Essex County Superior Court, which has brought a civil suit with a jury request for the actions of UBS in withholding the money in the probate court. So we're overall, needless to say, pretty pleased with the instructions that the judge gave, because they ended up determining that Bernadine Matten did have the capacity to make the decisions that she did, that the UBS had to take the instructions from her representatives, and that ultimately the funds should be turned over. What we're not too happy with in some instances, however, are the incorrect findings of fact and rulings of law that the court ended up submitting. Very comprehensive. We give the judge credit, trial judge due credit on that front. She certainly did.
I poked around the Superior Court case file, but of course I can't hear any arguments that are going on. It didn't seem to me that the judge had ruled on the collateral estoppel claim. Is that right?
It hasn't been ruled on. You're correct, Your Honor. But our concern is that if we didn't take an appeal with respect to the what we consider to be the unsubstantiated findings of fact, then that would come back to haunt us in the civil action in the Superior Court. So. Again, going back to the issues that obviously we have no problem with is that Bernadine was capable of making and appreciating her own decisions regarding the 2019 power of attorney and the First and Second Amendments made to her 2014 trust. Second one is that the UBS shall take direction from the trustees as nominated in the First Amendment to the 2014 trust, and to the extent necessary shall accept the Second Amendment to the 2014 trust and the 2019 durable power of attorney as both valid and binding. Bernadine, and this is the third one, obviously, that Bernadine and Thomas are co-trustees of the trust, and UBS shall take directions to any trust accounts held by UBS from the co-trustees in the fiduciary capacity. And finally, and probably most importantly, that Bernadine had the requisite capacity during the necessary times in question to execute the First and Second Amendment to the 2014 trust and the 2019 durable power of attorney. However, where things started to go off track is the trial judge ended up finding that Bernadine did not have the full understanding when she asked to have her accounts liquidated.
Yeah, I'm not sure why that matters, because there's another instruction right after that, which instructs just that it be transferred to this Mr. Conti.
Yes, yes, a separate financial advisor.
And of course, you don't actually want it liquidated. I mean, when I left UBS, I just had my stocks moved to Janney. I didn't had them all sold and a check. That's not the way you'd want to do it, right? I mean, I don't understand why that particular finding sort of affects anything. It's not an instruction that you'd want done now, right?
Well, first of all, I'm not sure that it was necessarily used as a term of art to liquidate like bring everything to cash. It may have been that it was just to transfer the account, because initially Bernadine wanted to transfer the account away from Roger Lapointe to Chris Palalis. And they did that for all of 2 days, and then they transferred it back. But the concern that we have is that when she asked for the account to be liquidated, even if it was to be used and considered a term of art, that they wanted all the stocks and bonds and everything reduced to cash, the time that she asked that to be done, it was done on a telephone conference with both Roger Lapointe and her attorney at the time, and actually still was right up through the litigation, Albert Pederuto, who was her estate attorney. So he was the one that was actually asking that be done, and they refused to do it. So that took us then down a course where there was, well, as you can see, there's conflicting reports as to what was actually done, whether the account was coded, whether it was not coded, whether it was frozen, whether they...
Yeah, that's something that I found confusing. I'm certainly going to ask your friend about that. As the judge says, it's not quote unquote, and she uses quote unquote, I'm not using quote unquote, she uses quote unquote frozen, but that they weren't executing any requests regarding the account. And it's, so I'm trying to understand, it seemed like once UBS got concerned, they basically weren't doing anything other than the monthly distributions that have been done and not responding to executing any requests. Is that what the evidence is? I have not read the whole trial transcript.
Well, the whole thing's confusing, to be quite frank with you, Your Honor. I'm not sure why they did what they did, starting with the inappropriate actions that they took to code her as a vulnerable client. Now, one of the things that the judge did in her findings of fact was that she said that the UPS did everything in accordance with their procedures. Well, if you go back and look at the trial exhibits, most importantly, trial exhibit number 19, which was it's the FINRA rule, the 2165 rule, doesn't say anything about, and in fact, the UBS's documentation doesn't say anything about freezing the accounts. It says that once you've coded that person as a vulnerable client, then you take extra precautions with respect to the handling of the account. So at a minimum, if that were the case, and even if she wasn't in this case, but even if she were coded as vulnerable, then they should have at least allowed the account to be changed in-house from Roger to Chris, but they didn't. They actually moved it right back. It's double offensive. They did it incorrectly in the first part, not allowing it to be transferred or liquidated.
Well, the evidence, except for that 2-day brief movement, the evidence, does it show that there was no instructions that were complied with during this time? Is that correct, or are there instructions that were executed?
Do you mean from Bernadine or her attorney?
Yeah.
Well, no. At that point, they had already asked for it to be liquidated. They asked for it to be. I'm sorry. They first asked for it to be switched to another. Actually, I'm a little unsure about the timing on that. Maybe very close in July of 2019. But the problem is no matter what effort that they made, the instructions weren't honored. So for instance. And as you know, we claim most of the problems began in 2019 after Roger Lapointe also started representing one of the defendants, who was Patricia David. She started feeding information to Roger saying that I questioned Tom's authenticity and whether he's truthful. We've had problems. She forwarded a note from Dr. I'm going to hack this up, but Stupensky, Dr. Stupensky, who didn't designate Bernadine as having dementia, just said that she had some cognitive issues, some remembrance problems. In fact, at no point in time was there any indication that she did suffer from dementia. That is a medical term of art, and it was used by the associate of Roger Lapointe, Nicole Johnson, I believe her name was, and she put it in the request to have it coded. But again, not coded. The client wasn't coded. They did a 2 or 3 day investigation, and things only started to roll out of control after that, because there was then a complaint made to the elder services, and I'm not sure, I think it was Methuen, about issues with respect to abuse of Bernadine, which they did in an investigation, and after that, when the investigation was all said and done, they found nothing. They closed the case. So Attorney Petaruta once again requested that the funds be released. Now, of course, in the interim, there was a change in some of the documents. In addition to the First Amendment, the Second Amendment changed the beneficiaries of the trust. So it went from 5 individuals, which were the Mary Ray Smith, Patty, David, and Thomas Matten, and to Patty, David's 2 young daughters. It now went to a 3 designation, which was Patty, Mary Ray, and Tom, which was not an unusual allocation for a trust to be done and given directly to children, as opposed to having included prior grandchildren.
Could I steer you back to your initial claim with the erroneous factual finding about this call? Was that the August 7th call, the call to liquidate? Is that the initial factual finding you're challenging? Again, that.
Do you have? Yes, it is.
So based on the judge who heard the testimony, who conducted the trial, how could we find this is clearly erroneous? She credited Mr. LaPointe in his notes over the recollection of counsel. And she obviously found there's some very concerning portions of that call that led her to conclude that her capacity may have been impaired, including not knowing who her accountant was, although she'd been working with him for 20 years, for instance. So how was that clearly erroneous, what she concluded?
Because there was nothing to support that designation at that point in time. The August 7th call, again, preceded a lot of the doctor's notes and everything else that ended up going into the account, or at least going into the file to try and substantiate the claim for it being a vulnerable client. But if, again, go back to Exhibit 19, which is a FINRA rule, it gives you 15 days to do something. You can do an investigation. They did a very limited investigation, and the judge heard all of this. It was only over 3 days, and I believe it was in July. But they did nothing further at that point. So they had a choice. They had a choice to either file and look for guardianship or something else in a probate court, or release the vulnerable client designation. Being a vulnerable client doesn't mean you
need to be conflating, or maybe I'm not following, these, on appeal you're challenging these determinations. But from that you argue on more legally what UBS did or didn't do, what they should have or shouldn't have done. But you're appealing the judge's conclusion, a factual conclusion, correct?
No, we're appealing the substantiated findings of fact, not the conclusion itself with respect to the declaratory judgment or the instructions, because those actually were in 2 separate documents. So that's why it's a very unusual circumstance to be in here arguing that we got what we wanted ultimately with the declaratory judgment, but it's causing problems as a result of the subsidiary findings that got us to that particular point in time. Doesn't hurt here, even with respect to the other issues that we've raised in our brief with the changing of the burden of proof and the time allotted and so on and so forth, because ultimately those issues didn't make any matter. We got what we wanted in the first place. The problem, though, is that it can come back to haunt in the civil action, and more importantly, despite the memorandum from the plaintiffs, UBS, agreeing with the recommendations by the GAL and not filing an appeal to any of the instructions of the judge, they still didn't release the funds. As of the time we filed this particular appeal, they still hadn't been refunded.
You stated ultimately those other issues didn't matter. So you're withdrawing your appeal on,
No, because I still think it's important on the issue of shifting the burden. It should never have been shifted to Thomas. It should have stayed with UBS because they're the ones that were
why
filing.
isn't that moot?
Pardon?
Why isn't that moot?
Well, it's moot to the extent that it didn't have any impact on the ultimate decision, but it may be of great concern to future cases where they want to know where someone didn't participate. I mean, it fell within the ambit of the Moretti case and the Urban case, and he didn't take her
So
off.
after the trial, the judge has this whole hearing on whether to change where the burden goes on that. And then it just kind of disappears. Am I missing some ruling?
It
No.
did. It kind of disappeared. We raised the issue of burden shifting a number of times.
Yeah, no, I
I
see
was
that,
not
but,
I was not trial counsel at the time that the issue was first set in front of Judge Basinius in December of, I believe, 2021. And as soon as we came into the case, we did file a motion for reconsideration of the shifting of the burden. It ended up, because Tom was unrepresented at that point, the court had allowed a motion the day before to allow withdrawal of his counsel. He didn't participate in the discussions and unfortunately didn't have much input at that time frame.
all right, well, thank you very much.
Thank you.
Whenever you're ready, Counselor. It's finally afternoon.
Okay, that's what I was
It's
going to
close.
check. Justices, my name is Sandy Durland of Warner, Federico, and Ryan, and I represent UBS in this matter. Good afternoon to all of you. I do want to pick up on something Judge asked my colleague, and that is the findings of fact. Here, I think you need to draw a distinction because the judge made findings on the intrinsic parts of the complaint that UBS brought. First, relating to capacity and the validity of the amended estate planning documents, and then whether the company acted appropriately. The challenge, as has been acknowledged, really speaks to this other proceeding and trying to protect, and I think the words was that it doesn't come back to haunt them in that proceeding. But the reality here is the evidence, it was significant evidence in this case, multiple witnesses, lots of exhibits, 2 full days of trial. And the judge's findings are more than amply supported by the evidence and the inferences and conclusions that she drew, and as the panel knows, really aren't subject to second guessing, and that's really what they are asking in their appeal. Counsel focused on a FINRA rule, and he referenced it on a number of occasions, 2165, but that's an overblown issue. The concern that the company had were the so-called red flags that led it to code the account as being vulnerable, the vulnerable client coding. That was not a freeze. It was simply a hold.
So what instruction given by Bernadine or her lawyer after Ms. Wolf got involved was followed by UBS, besides the 2-day switch? Is there even a single?
Oh, you mean the
Any instruction? Give me any instruction.
inadvertent transfer?
Any instruction that happened that was followed?
When there was discussion, counsel brought up the issue of the August 7th, I think, telephone call where it ended abruptly. There were no further instructions made until the trial occurred. So And counsel says, he brings up a matter not in the record that the money still hasn't been transferred. The company has been waiting for instructions, had been waiting for instructions.
Instructions from the court or instructions from Bernadine?
Post-judgment for the instructions. But prior to that point.
So, I mean, LaPont testifies when the judge asks him, what if she called and said, I want a distribution of $10,000? He says, no. If an appointed person by the court, like a guardian, called in, which makes it sound like once this got coded, regardless of what that's supposed to mean, you weren't accepting any instructions from Bernadine until the court gave you instructions. Is that right?
Well, what specifically in this case, there was that telephone call where it was a very confusing telephone call vis-a-vis the initial instructions to liquidate. And the discussion was had with Mrs. Matten about whether she was understanding what was going on, the tax consequences and the like. That led to no further instructions once that proceeding ended. And the record reveals how Susan Wolf, who is responsible for compliance at the Boston office, she herself looked into this. She herself contacted Mrs. Matten and attempted to ascertain what her wishes were. And that only led to further concerns. The evidence shows that, and the judge found, there were 26 separate red flags which were met, the criteria was met, which led to the vulnerable coding, which only puts a hold and additional layers of security.
He said only puts a hold and only does additional security, but this LaPont testimony that I just read to you, he said that without an appointed person by the court like a guardian, they weren't going to do anything. So is there evidence that says otherwise?
Well, I don't think Mr. LaPointe is not responsible and cannot speak for the company on those sorts of issues. So even had he been contacted by someone, it's not up to him in the context of what was going on with Mrs. Matten to make that determination. That would have been somebody higher up the food chain, to use a phrase. And that is why Susan Wolf got involved. Because that's her responsibility to look into these matters when these concerns arise. So the fact that Mr. LaPointe said that, I don't think is of any import, and the judge didn't really credit it any more than perhaps making reference to it. Her findings speak to the concerns raised, the information that was being received regarding Mrs. Matten's intermittent testamentary capacity, none of which is inconsistent necessarily with what ultimately occurred. In the moment, the company was receiving...
So why wasn't it transferred to Conti?
Why wasn't it?
Yeah, why wasn't it transferred within the company to Conti?
At the time the request was made, Mrs. Matten then evinced confusion about whether she had actually even made the request. So there was this confusion back and forth and contradictory information being provided to the company, all while they were looking into the issues. And after that final request was made, there was no further request made until the trial. So there was a gap of time, to be sure, but that gap of time was not because UBS continued to ignore what was going on.
Why didn't UBS do that after they got the report saying that she was competent? Make the transfer, the last transfer they've been asked for?
Well, there's a lot of reasons, Your Honor. I mean, there was still inconsistent information. The Guardian did conclude, if that's the report you're referring to, the Guardian did conclude that he felt she had capacity. He also concluded that the company acted reasonably. And there were still a difference of opinion on whether or not that capacity was in fact in place, because there were still other confusing information being received. The Guardian is just one component of the whole thing, as you know. A neuropsych exam also was somewhat equivocal at times. The daughter, one of the daughters was still in contact with her mother, providing information about her. She was really confused. LaPointe Nicole Johnson, Susan Wolf, they were all seeing and observing this in the moment. And so despite the fact that there was this back and forth, they put the hold on, and it was simply that, a hold. And then the request after August 7th, I believe it was, Your Honor, it never occurred. So that's the issue here. I mean, the appeal speaks to whether the company acted reasonably. And when presented with this sort of information, financial institutions like UBS can't just look away. They have to act. They did act. And the evidence lined up with a whole list of concerns. And those concerns were never allayed until the matter went to trial. And despite the fact that there was evidence at times suggesting capacity, evidence suggesting at other times there wasn't capacity, the company was in a bind, to be candid. Hence, they brought the action. And it wasn't until, the decree came down that the company finally got the direction that it had been seeking. Now, I'm not sure if Your Honors have any other questions about the findings, but I think there is ample evidence on the issue of reasonableness by UBS to dismiss that claim on appeal, because I don't think counsel's brief, the appellant's brief, adequately addresses those issues given the evidence, given the judge's reasonable conclusions. And that's where I think the analysis ends. I'm led to believe from argument that the issues of the burden of proof and the time management and the adverse inference drawn, they're not waived, but as counsel has acknowledged, they really don't play into it. And as the judge found that, when the burden was shifted, long before the trial, there was information provided to the motion judge about whether or not there was a Cleary, Rempelakis, urban issue. And she made, based on admissions, a request for admission to Mr. Matten, she determined that there was a question whether Cleary at all applied. So nothing was done with that ruling. There was no challenge. It wasn't challenged until long after. The motion for reconsideration was far past 30 days. It was literally at the 11th hour. And due to how Judge Ulwick manages her trial through her trial scheduling order, that was not scheduled before trial, and the judge was clear.
That
I'm not
order
gonna hear it.
may not matter, but that order is plainly premature. Just having a fiduciary doesn't get you with the change. You also have to be involved in the transaction and not have independent, in urban, it was at summary judgment that
Right, no, that is true, and ultimately, that is what the judge found, that he was, Mr. Matten, Thomas Matten, did have a fiduciary role, but he was not involved in the transfer. But that wasn't clear at the time, so even if the the shifting order was premature, it ultimately had no import whatsoever. And that counsel has effectively conceded that. And the same is true for the time management issue. Judge Ulwick has a very idiosyncratic process in how she manages her trial. It's laid out in the trial scheduling order. Nobody complained about it until the trial started, and we're all trying to manage our time.
And do you agree with your friend that post-trial hearing sort of just never went anywhere? There's no clear ruling except to what we can deduce from the findings?
What?
There's a post-trial hearing on whether the burden should be shifted.
There was a post-trial hearing on, I think, and there was also the issue of the adverse inference.
Yeah. The adverse inference she addresses in the findings, but I didn't see anything that really clearly addressed the burden. after that. I didn't see it. Your friend said.
No. I would agree with that. But I mean, ultimately, by the findings and the decree, obviously, Mr. Matten met his burden because the finding was, he didn't violate his fiduciary responsibilities, et cetera. He wasn't involved, as Your Honor pointed out. So, it's sort of an intellectual exercise on these final points: time management, burden of proof, adverse inference. Maybe the judge did make an error. If there was an error, clearly it was de minimis or harmless because it had no impact whatsoever on what she ultimately found, which favored Mr. Matten's position. And certainly, to the extent they appeal what the findings were about UBS, those other parts, that has nothing to do with UBS per se. It's just complaining about what the judge decided without any import, in my opinion, because there was it had no effect on what she decided. And she even made that finding. She made that finding insofar as the burden of proof is concerned. So anyway, if your honors have any other questions, I certainly will rely on my brief.
All right. Thank you very much. Of course, you can't go anywhere. I'll call the last day, excuse me, I'll call the last case of the day, number 24P 744, Hill versus Del Plato.
Good morning, Your Honors. Let me be the second person to wish you good afternoon. My name is Sandra Lundy, and if it please the court, I'm appearing here today for the appellant Mother Caroline Hill. Your Honor, even with the issues of removal no longer in this case, the record discloses serious errors in the judge's findings and rulings on physical custody, legal custody, and child support that merit the vacating of her judgment awarding father his complaint on modification. And I want to step back and talk about three things that we know from the case before I talk about those specific errors. First of all, there was no question that at the time of trial, Sophia, who had been in her mother's primary care for almost all of her 11 years, was happy, healthy, well-adjusted, sociable in every school she was at, doing well academically, and closely bonded to both of her parents. There was no question that she hadn't developed any special needs or that there was any material or substantial change in the mother's health or mental health or other circumstances that would impact her continuing ability to take proper care of Sophia. And in fact, the father admitted on the stand that the mother had been taking very good care of Sophia. And also, there was no evidence that father had missed even one day of his scheduled parenting time with Sophia because of anything that the mother said or did or didn't do. And in fact, the evidence was that all of the time that the father missed, he missed because he had other things to do, and that the mother went above and beyond what she was required to do legally to make sure that the father and the child were connected, even paying for his airfare, offering him a place to stay, buying his groceries, buying him a phone. For all that, the judge decided to disrupt the status quo and take primary custody away from the mother and give it to the father. And in doing so, she made 4 series of critical errors. I want to list them first, and then I can talk about them individually. The first was she gave decisive weight to the child's preferences as stated in a very cursory interview with the probation officer. The second is that she used the child's hearsay statements as substantive evidence to sustain the father's burden of proof. The third is that the judge ignored the impact that the change in primary custody would have on the relationship mother and the child. And in fact, she says almost nothing except some negative remarks about the mother, about the aspects of the mother's parenting. And fourth, the judge substituted speculation about possible future harm to the child for evidence in making her rulings. Now, I don't think there's any question reading the judgment that the judge gave outsized hefty weight to the preferences of the child. And we know from Hale...
Really? Where do you get that from?
Well, the judge mentions the child's preference many times in the decision. She says that the child preferred to live with the father, and that she thought that that was a good, let me see if I can get the exact wording here. I'm sorry, I'm not putting my hand on it, but I think that it's clear that that was an important factor for the judge. Okay, let's look on page 12 of the rationale and judgment. Sophia articulately reported that she's comfortable, she's able to be herself. She emphasized she makes mistakes. If she makes mistakes, her father won't put her down about it. Contrast with the mother. The court finds that, Sophia made comments about what the mother said. Sophia has been thriving in father's custody. So I think that it's clear.
Preferences. It mentions the preferences, but then there's all these non-preferences, how well she's doing, the fact that she's thriving, A- in math, Belmont schools being good, and no other mention of the preference that I saw.
I think it's pretty evident how she made her findings, that she took into account, serious account, Sophia's preferences. And I think that it's also clear that she used Sophia's statements for substantive evidence rather than her state of mind.
But you didn't object to that, right?
Yet there were objections to what Sophia said, and there were constant objections throughout the trial as to Sophia's statements, and it was also...
Where I find an objection to substantively considering Sophia's statements from the GAL report?
From the... well, I don't think you would have. I don't think you would have, because it was unclear that that's, until we got the judgment, that that's how the judge would use those statements.
But if you don't object to some evidence coming in, you don't ask her to be limited, doesn't it come in for all purposes? In a DCF case, there's always a motion in limine that says, don't consider these reports except for the primary fact things, and I don't see that here at all.
Well, there's several instances where the judge herself said she wasn't going to consider the child's statements. Mother started to say something that the child said, father started, and the judge said, I'm not hearing any of that.
Where did she say she wasn't going to consider them substantively? I didn't see that.
Well, I think that there were a number of times that the trial counsel raised objections to the report, and I think raised objections in the cross-examination, implying that the probation officer, I still want to call them family service officers, that the probation officer was taking things for the child to be true. And the fact is, looking at the interview, it was uncorroborated. It was, some of the questions were leading. There was no context. For instance, Sophia came in and said, my dad wants me to tell you where I want to live. Well, as any guardian ad litem would say, well, what do you mean? What did he tell you? What exactly were his words? When did he tell you? How often?
Where's that in the report? I didn't see that.
That's in the first page of that's one of the first things that Sophia says to the family service officer. That is on, I believe it's on page 1 of that.
She reported, my dad wants custody of me and I want to live with him. I don't see where it says
She
my
says,
father.
That, I'm sorry, Your Honor. On page 2, she says, Sophia asked if she knew why she was meeting this officer. She says, my dad wants custody, I want to live with him. She further added that she was supposed to tell you my side of the story and where I want to live. What is supposed
Wasn't that what she was supposed to do?
No, she's supposed to
She's not
tell-
supposed to tell her own side of the story and where she wants to live?
Well, I think that it's fair to say that there are indicia of coaching all over that statement.
Okay, where's the
because
indicia of coaching?
the dad told her what to say. The dad talked to her before, he told her what the substance of the interview was going to be, and he told her
Tell your side of the story and where you want to
your
live.
side of the story.
And where you want to live. How's that improper? That's exactly what she's supposed to do at the,
Well, as a guardian ad,
right?
as a guardian ad litem, myself, I know that one of the things you tell a child before they meet a guardian ad litem is there's a custody. Obviously, the father was telling the child about the custody dispute, and what the proper way to prepare a child for these kinds of interviews is to say, we can't decide on something and somebody from the judge wants to talk to you about it. This was not a neutral message she was getting from the father. It's clear. And if I may talk about, for instance, the substance, because there was a clear error in the findings from the judge here. If you look at, the judge found that the mother interfered with the father's parenting time. Now, I said there was no evidence, and there is no evidence, that the mother actually deprived the father of any scheduled parenting time. But Sophia said to the family service officer,
hold on, where's that finding?
if you look at the father's, that she interfered.
You said there's a finding, the judge made a finding that mother interfered. Where's
Yeah,
the finding?
She uses the word interferes.
Interfere?
This is in, I'm sorry, I'm looking at
Finding
Is it
37?
37?
47.
37? Is that the one you're talking about?
Yeah,
Father
I'm
testified
sorry,
credibly
but I
is
don't have-
concerned that mother is attempting to interfere in his relationship with Sophia.
Right. Now,
That's not quite the same thing as finding that happened, just finding that he's concerned about it.
well, but if you read the opinion, I don't think you would ever imagine that father's parenting time was ever interfered with. Now, Sophia is the one that said, my father, tell the judge I want my mother not to cancel my father's parenting time because he's mad at her. That comes from Sophia, who is, and she mentions the trip to the Dominican Republic. Well, the father was not shy about his criticizing the mother. He mentioned nothing about a canceled trip to the Dominican Republic, either in his testimony or in his affidavit. So the child uses the word canceled, and I think we can infer that that influenced the judge to think that the father's parenting time was interfered with, or that she attempted to interfere with the father's parenting time. Now, it's also true that the father concedes in his brief, and we're looking at page 30 here, that there was no overwhelming evidence of hostility between the parents, and that they just experienced typical bumps in the road in parenting time. That's incompatible I would say that that's a concession by the father, that there wasn't anything that was so out of the ordinary in the bickering and sniping back and forth that would suggest that mother had affirmatively interfered with the father's parenting time. Why would you say that the parents could get along for purposes of legal custody and not understand that that also meant that they could communicate for all purposes? They said communicate for purposes of legal custody. So really much of the evidence comes from Sophia about the interference and the extent of interference. It's also true that the judge completely failed to consider the effect on mother and child of the relationship and the change in custody. You know, we know that a judge in finding for and making a custody determination has to look at the whole picture. The judge ignored the entire whole picture of the mother's positive influences on Sophia from the day that she had primary custody after the divorce. And I think the father even concedes that at least until 2022, she took really good care of Sophia. You can't find that in these findings. The judge did not look at the entire picture when she decided to change custody. What did it mean that the mother took great care of Sophia? What did it mean for the disruption of this relationship to say that now we're totally transferring physical custody of Sophia to the father? I would like to say just one thing about child support, Your Honor. You know that what the judge did is that she took a figure from mother's contract salary at the time of trial. She annualized it came out to $187,000. There was no evidence that she ever made that much money. Then she applied it prospectively, even though mother...
I don't understand. Isn't the judge supposed to take the income of both parties right at the time they're doing it and then issue a child support award based on what the worksheet gets?
This was a contingent award. The judge could have said...
Right, but so what? Then when the income changes, it's automatically a modification situation if the income's changed, right?
But no, and look what the judge did.
I thought if any time the guidelines are different than the current order, that's an automatic modification.
Well, then you were asking the mother to come back a month after trial if she got a different job or when she got a different job.
But why isn't that wrong that when a party's income changes, goes down, that they should come back and ask for a different child support?
Because this was based on a contingent fact part of the income, and the judge applied it retroactively to include at least 2 months when the mother had different employment, and there was no testimony about how much she made in those 2 months. So it's hard to see that it wasn't a penalty for at least those 2 months of retroactive child support.
So you're saying after the financial statement, there was 2 months, and she had different income then, but you didn't tell the judge?
No. After the child support was made retroactive to August 17th, which is when the father had custody. Well, the record is clear that from August 17th to either October 31st or November 1st, the mother was not employed by that employer. She had 2 other employers, and there's absolutely no evidence about what she made in those with those employers, and there's no basis for inferring that she made that much money with those 2 employers. In fact, none of the parents...
So what's the judge supposed to do if your client doesn't tell her what her income was at that time?
Well, income wasn't that much of a part of the case. I don't think that either side expected a retroactive adjustment of child support, and there was no evidence about it from either side. So certainly, if the judge had questions about retroactive application, she could have asked for some further briefing on that. But there was no basis for which to say that the mother's salary, which was inflated by at least 1/3 by the amount of her travel allowance, which was temporary, should be applied both backwards and forwards. And I see my time is up. If there are no other questions,
Thank you.
thank you.
Welcome back, Counselor.
Again, I am still Sandy Derlin, Warner, Federico, and Ryan. Again, good afternoon. If I may, I'd like to address briefly the issue of the mootness of the appeal. I did bring that request earlier on in the single justice, deferred it to the panel. Now, the issue of removal has been mooted, and we agree on that now that the mother has relocated to Massachusetts. In fact, I also got leave to allow my client and the mother, if she so desired, to bring a modification action, and there is one pending at the present time.
Right, but it's for a new pickup place, how you do the tax dependence,
Yes.
and the summer vacation. I don't see how that's going to moot out anything that's before,
no.
other than the removal of the
Let
state,
me-
which is definitely moot.
Right, let me just explain what my point, and I won't spend a lot of time on this. The legal custody and the parenting plan that was issued in the judgment, you have to consider the context in which it occurred. And that was mom living in Long Island, dad living in Belmont. And that clearly had an impact on the judge's decision. And the fact that mother has now come to Massachusetts certainly, in some respects, undermines the issue on appeal about whether the parenting plan is excessive or it interferes with mom's relationship with the child and the decision-making by both of these parties. That, the judge was aware and obviously aware that when she was confronted with the removal request, that if allowed, or if not allowed, and mom stayed in New York, you have to deal with the geographic realities involved here. And I think that drove some of the decisions on custody, legal custody, and on the parenting plan. And I suggest, at least, my position, I'm going to go on and argue the merits of the decision, but I do think there is a question of whether those issues are also mooted, not the support, which counsel addressed. But I do think there are questions about that because, my client sought shared legal custody, but sole legal custody regarding medical decisions. And he was clear that it was based on a practical need to make a quick decision. And that's really what the judge decided here. I mean, and this gets to one thing on appeal, and that is, how do you do did the fig leaf custody and that's how counsel characterized it, was that valid? Was it supported? And I think, the way she crafted it is, I'm going to make both these parties engage in good faith negotiations before anything happens. And I think that that's supportable and it can be enforced. But she then says, but if there's a dispute after those efforts, Dad will make the decision. And again, there's this practical aspect of it based on where the parents are living. So anyway, let me move on from that, if I may. With respect to the, let me jump to the probation officer's report. That issue was very practically driven. The judge was clear that she wanted to get some input before the next school year started. And she was, and I think based, I don't want to speculate, but it was clear she needed something quickly. And that may not be something you would have gotten from a JL, regarding ad litem, as opposed to meeting with the probation officer. And so they had a brief meeting, and the probation officer was able to turn the report around relatively quickly as the judge requested. The probation officer's references to the child's preferences, I think, are entirely appropriate given the age of this child at the time, 11 and a half. Cases have said that a child of that age, the preferences can be considered, although they're not binding. And that's exactly what you see in the judge's findings in her rationale. Yes, she references what the child said and where the child wanted to live. And she makes findings on it. But it certainly wasn't the driving force in terms of the decision to change custody. I mean, clearly, if a review of the evidence and then the resulting findings, it's evident that that decision was based on trying to stabilize the child's living arrangement, given the fact that she had moved many, many times with mom and with dad, back and forth, given the fact that she was doing well in school, involved in extracurricular activities, making friends, all of the things that a judge considers in any custody decision, this judge considered. The preference was ancillary, and candidly could be ignored. And there still would be more than sufficient basis for the judge's decision on the parenting plan. In terms of whether it would interfere with mom's relationship with the child, well, I mean, the reality is she chose to live out of state. She brought the removal issue up and she was unsuccessful. The judge is then confronted. I need to do something. I need to do something practical. And really what the judge did is she in some respects, flipped the mother's proposal and gave it to her as if, what mom proposed with her removing the child, the judge effectively enforced with dad having custody. So, I think that it was a common sense decision with imperfect alternatives, which is that's the definition of a custody decision. And here, that's what she sought to achieve. Every other weekend and an opportunity during the week for a 6-hour visit with 7 days notice, which of course speaks to this removal, this moot issue, because, if mom had been living around the corner, she wouldn't need to give 7 days notice to spend time with her daughter in Belmont. So, but all in all, the decision makes sense. It's grounded on, in the evidence, and certainly I don't think unduly interferes with the mother-child relationship or somehow didn't promote the child's best interests, because I think it accomplishes all of that. Again, perhaps imperfectly, but we may achieve for perfection, we never achieve it. So, the same can be said for the legal custody. I alluded to it quickly earlier, but again, both parties, I think, acknowledged that the other was a good parent. Mom sought sole custody, dad sought shared custody, legal custody, decision-making. The judge effectively said, you two have had your issues. You've had communication issues. You've been, in my words, you've been unkind to each other. You've been difficult. But you've managed to work it out. You've managed to pull this off. You've parented well. But ultimately, if you come into a position where you can't agree after a good faith effort, we're going to let dad make the decision based on practical considerations. And again, I think that's well within her discretion. And I think that, the judge did have concerns about mom's parenting. I think she had concerns over her parenting style. Not to criticize her, but I think they had different styles. And I think that, the judge was just trying to, cobble together something that would work given the realities that she was confronted with. Now, let me just quickly address, if I may, the support issue counsel quickly tried to address. the financial statement that the mother prepared in this case is a snapshot. The trial is a snapshot. She didn't disclose any of her income that she didn't disclose the travel allowance that she got as a traveling nurse. That was put in a footnote.
I mean, so it's disclosed.
Well,
It isn't in
it's not
the
on the
front
first
numbers,
page.
but it's definitely in
So,
there.
Okay. I don't mean that to be pejorative. I misspoke. She didn't put it on the first page where all the income, receipts and so forth is meant to be listed. It was in a footnote. And as Your Honor pointed out, under the Morales case, child support is structured in the moment. And in this moment, she had a travel allowance. And it was entirely appropriate for the judge to consider that, which evidently is a tax-free receipt, which is why she grossed it up, to come to the level of income that she chose. That is exactly what Morales requires. And if she loses that benefit because she no longer is a traveling nurse, then it's appropriate for her to then seek the modification, which is a very low bar and effectively requires a $1 delta either way and the change occurs. So I think that concept on appeal is a bit overblown because of the way child support is meant to be structured on the fly in these sorts of settings. And I think that, well, I think that's all I'll say on it.
When you opened, you talked about how now that the parties are within the same jurisdiction, there's a modification proceeding, all of that is going to change. And that you had raised this issue of the potential mootness of many of these issues. Do you have a suggestion of how we should handle this, given that something else is pending that may change everything about it?
Well, that's my suggestion would be, I think the three big issues, removal, legal custody, and the parenting plan / physical custody, outdated term. I think all those issues really are mooted by mom moving back. That's my position. And I think this court could I think there's more than ample justification to uphold this decision across the board based on the evidence, based on the findings, okay? And that is certainly, Your Honors can do that. And I would welcome that. That's what my position is. But on the mootness issue, I think this court would also be well within its rights, or it would be well appropriate to say, you know what, those issues really are mooted. And if you're inclined to address legal custody, you're inclined to change the parenting plan, if you want to seek primary custody back, as you did have at one point, that should be done via the modification, which is now pending. And it's a far more, because if counsel succeeds on a remand, it's going back to the trial court. And that judge is then going to be forced to confront the issues that she can now address in the pending modification. So in some respects, the issues before Your Honors, I don't think you necessarily need to reach them. Perhaps the child support, yes. Although I don't know what she's doing now. I don't mean that flippantly. I don't know what her employment situation is. But, clearly that is going to be, that will be broached and likely changed under the Morales case, depending on what she's doing or maybe what she isn't doing. I don't know. But ultimately, this is all going back to the trial court, and which, is in a better position to deal with these issues in the moment, today, in terms of this child who's now probably pushing 13. So that's my suggestion. That would be my thought in response to your question, Justice. If you have any other questions, I will rely on my brief.
All right, thank you both. We'll take it under advisement. I'd like to thank our court officer. I'd like to thank our timekeeper, always the clerk's office, which makes everything happen, all the attorneys who have been before us. It's all been very helpful to us. And with all that said, court will stand adjourned until tomorrow at 9:30 a.m. in the Chief Justice Hale courtroom.